Cars, calling all cars. Be on the lookout for a brown-skinned guy, dog tags, cornrows, and Oreo spitting. Last known whereabouts is in Baltimore. Last seen with this guy named Juice.
One of the best in the business, spitting with a slick hand and holds up metal like kickstands. I am hip-hop designing the form of this man. A show searching for a star. Well, I'm Ed McMahon, one of the sharpest MCs out of Maryland. Only takes a couple blocks to build a Lego land. Only takes one shot for me to bury a man. Hey, girl, so in love, she wanna marry a man. I'm back on it, yes sir, I'm back on it. So international, they should call me foreign. So B.I.G. man, I should be enormous. So damn fly, I should be enormous. Lyrical boys tell MCs to join in. So Baltimore, these other rappers. So I'm an original scar. I teach you how to go hard and rip the skin from a snake and split a pea from a pod. I'm bad, and no rap quite like I changed. She never been a rapper that's good for this long, and no rapper can rap quite like I can. Well, never been a rapper that's good for this long. Will eliminate punks, little suckers and chumps. It's hard till you heard me, then your ego's strong. Don't make this ego dump you up and reload back up and leave your ego finito. What's up? I'm called Leo, mixed with Nino, better call your people. I get your girl dope, she call me cock diesel. I will not lose ever. I'm bad, destined to be the challenge. Conquer any that manage the system up on the canvas. Yes, I'm such a savage. Yes, I'm so the baddest rapper that spit with carrots. Yes, I got in the bed. No rapper can rap quite like I can. Guess I'm the baddest of the baddest. Plus I'm bad with a pen. Hey, yo, Yuki, take a look at what I done. Used to rock in the basement, now I'm number one, and I'm bad. And no rapper can rap quite like I can. She never been a rapper that's good for this long, and no rapper can rap quite like I can. Well, no rapper that's good for this long. Trust me and Shell Heads and Levi's. Battle me, watch ride. You'll walk in the bushes, so tell me bye-bye. For the competition, I'm as real as can be. So you can bet your favorite rapper ain't realer than me. I bar, I'm bad. All the rappers know when I enter the place, they say, yo, there he go. And I'm the pinnacle. That means I reign supreme. And I'm notorious, not from Brooklyn, but I'm B.I.G. And I ain't from West Coast, but I'm P.A.C. And I ain't LL, I'm just a G.O.A.T. And a dope MC in the place to be. So by now, you already know that I'm B.A.D. I bars the ride, so you better make way. If anybody in the crowd, they say the kid don't play. And I will not lose ever. I'm bad. And no rapper can rap quite like I can. She never been a rapper that's good for this long, and no rapper can rap quite like I can. But never been a rapper that's good for this long, and I'm bad.
It's your boy D. You know how it is on your road to riches.
Cars, calling all cars. Be on the lookout for a brown-skinned guy, dog tags, cornrows, and Oreo spitting. Last known whereabouts is in Baltimore. Last seen with this guy named Juice.
One of the best in the business, spitting with a slick hand and holds up metal like kickstands. I am hip-hop designing the form of this man. A show searching for a star. Well, I'm Ed McMahon, one of the sharpest MCs out of Maryland. Only takes a couple blocks to build a Lego land. Only takes one shot for me to bury a man. Hey, girl, so in love, she wanna marry a man. I'm back on it, yes sir, I'm back on it. So international, they should call me foreign. So B.I.G. man, I should be enormous. So damn fly, I should be enormous. Lyrical boys tell MCs to join in. So Baltimore, these other rappers. So I'm an original scar. I teach you how to go hard and rip the skin from a snake and split a pea from a pod. I'm bad. And no rapper can rap quite like I can. She never been a rapper that's good for this long, and no rapper can rap quite like I can. Well, never been a rapper that's good for this long. Will eliminate punks, little suckers and chumps. It's hard till you heard me, then your ego's strong. Don't make this ego dump you up and reload back up and leave your ego finito. What's up? I'm called Leo, mixed with Nino, better call your people. I get your girl dope, she call me cock diesel. I will not lose ever. I'm bad, destined to be the challenge. Conquer any that manage the system up on the bed with a pen. Hey, yo, Yuki, take a look at what I done. Used to rock in the basement, now I'm #1, and I'm bad. And no rap quite like I can. You never been a rapper that's good for this long, and no rap can rap quite like I can. Well, never been a rapper that's good for this long. Me and Shell, here's and Levi. Battle me, watch ride. You'll walk in the bush, so some of me bye-bye. For the competition, I'm as real as can be. So you can bet your favorite rapper ain't realer than me. Akbar, I'm bad. All the rappers know when I enter the place, they say, yo, there he goes. And I'm the pinnacle. That means I reign supreme. And I'm notorious, not from Brooklyn, but I'm B.I.G. And I ain't from West Coast, but I'm P.A.C. And I ain't LL, I'm just a G.O.A.T. And a dope MC in the place to be. So by now, you already know that I'm B.A.D. Akbar's arrived, so you better make way. If anybody in the crowd, they say the kid don't play. And I will not lose ever. I'm bad. And no rap can rap quite like I can. Never been a rapper that's good for this long. And no rap can rap quite like I can. But never been a rapper that's good for this long. And I'm bad.
It's your boy D. You know how it is on your road to riches.
Cars, calling all cars. Be on the lookout for a brown-skinned guy, dog tags, cornrows, and Oreo spitting. Last known whereabouts is in Baltimore. Last seen this guy named Jimmy.
And now rockin' with one of the best in the business. Spittin' with slick hand and holds up metal like kickstands. I am hip-hop designing the form of this man. Yo, searching for a star. Well, I'm Ed McMahon, one of the sharpest MCs out of Maryland. Only takes a couple blocks to build a Lego land. Only takes one shot for me to bury a man. Hey, girl, so in love, she wanna marry a man. I'm back on it, yes sir, I'm back on it. So international, they should call me foreign. So B.I.G, man, I should be enormous. So damn fly, I should be enormous. Lyrical boys tell MCs to join in. So Baltimore, these other rappers is so I'm the original scar. I teach you how to go hard and rip the skin from a snake and split a pea from a pod. I'm bad. And no rap quite like I can. You never been a rapper that's good for this long. And no rap can rap quite like I can. Never been a rapper that's good for this long. We'll eliminate punks, little suckers and jumps. It's hard till you heard me, then your ego's strong. Don't make this ego dump you up and reload back up and leave your ego finito. What's up? I'm called Leo, mixed with Nino, better call your people. I give your girl dope, she call me cock teeth. I will not lose ever. I'm bad, that's gonna be the challenge. Call the any that manage the system up on the canvas. Yes, I'm such a savage. Yes, I'm so the baddest. Rapper that spit with carrots. Yes, I got in the bed. No rapper can rap quite like I can. Guess I'm the baddest of the baddest. Plus I'm bad with a pen. Hey, yo, Yuki, take a look at what I done. Used to rock in the basement, now I'm #1, and I'm bad. And no rap can rap quite like I can. You never been a rapper that's good for this long. And no rap can rap quite like I can. Well, never been a rapper that's good for this long. Me and Shell, here's and Levi. Battle me, watch ride. You'll walk in the bush, so some of me bye-bye. For the competition, I'm as real as can be. So you can bet your favorite rapper ain't realer than me. Akbar, I'm bad. All the rappers know when I enter the place, they say, yo, there he goes. And I'm the pinnacle. That means I reign supreme. And I'm notorious, not from Brooklyn, but I'm B.I.G. And I ain't from West Coast, but I'm P.A.C. And I ain't LL, I'm just a G.O.A.T. And a dope MC in the place to be. So by now, you already know that I'm B.A.D. Akbar's arrived, so you better make way. If anybody in the crowd, they say the kid don't play. And I will not lose ever. I'm bad.
I got I might as well just sip some water first right now because I know this shit about to be hot when I'm about to spit. You feel me? I'm so Baltimore, LA getting wetter than a harbor. So high, with Bugatti from my grave, cause my whole city starving. From a cruddy town, front you pounds like on you, drop a bag when I crash the Mondawmin. So be more, get mellow, sign to Brooklyn. Only God and Pac know the pain that I took it. Y'all watch the while, nigga, we lived a while. Every day is murder for power. No 50 a job, I'm writing murder with no ink on no tails from Irv Gotti. AB, this is body bust up like John Gotti. See your spirit to the sky like BWI. Nothing above eyes except for my eyebrow. And the God, sip the blood of Jesus to wind down. Put an O in your cap, all that cap and dummy. Go and need a book of matches to match with dummy. Swimming in the city, you sin overlapping money. Trumping line, my city gon' need armies and tanks. I bet the bank, these punchlines hit harder than tank. I put my life behind these bars, better grab me shake. I got that work up on the block like Benny Blanks. I'm on the avenue, show me gratitude. Pull up, diamonds dancing like the avenue. You was never there, so you never knew. You know I double up, 2 times 2, 410. That's who I'm signed to. It's dummies in my city, we ain't mindful. So no fees, hit the licking from the slow goes. You pay me half up front, you half for the low. I be in your chick box like I'm UPS. I give a God day, so you know she blessed. Bust down a lick with Philly niggas like I'm YBS. We dodging bullets every day, how you gon' challenge us? Man don't know me for real. I wrote a letter to Hove. Emmy know me for real. Stokey know me for real. Tell them broken the deal. This that Percocet flow with that fentanyl feel. Get money.
But I know that there's more. More for you, more for us.
Children, rain all night long. Didn't it all, oh my Lord. Didn't it rain? Didn't it rain, children? Rain all night long. Didn't it all? Didn't it all? Oh my Lord. Didn't it rain?
You can't run from it. You can't deny it. You can't pass it off. It's your call. God knew what he was doing. He knew who he was calling. And he expertly and intricately detailed every aspect of your life, your being, your persona, your psyche, your physicality, everything about you, from the texture of your hair to the color of your eyes to the way that you laugh to the fingerprint on your thumb. And everything is connected to your calling. And until you walk into the fullness of the thing that you were created for, you will find yourself frustrated. You're called.
Meadow Rose, come here. Girl, you know that I want it. I know you're getting lonely, and that's why you call me. You know that I'm coming. You know that I want it. You're making me horny. Wanna know how it tastes, baby? Can't wait, cause this shit sound like black boots, show the seat grinding. Attitude, but I got you, baby. We gon' keep the thing winding. All night can't stop you, baby. No one ain't with the fake shit. What's the 411 is, baby? It's not back in brand new. Girl, tell me what must I do? Must I do? So tell me, what must I say? What must I do to show how much? Hold up, wait, this shit, Zelle. Black boots show the secret, and I want your body. Hey. yeah. I love my body, yeah. I know you get rowdy, yeah. Wanna know how it tastes, baby? Can't wait 'cause this shit sound like Bruce trying to see grinding. Attitude, but I got you, baby. You gon' keep the thing running all night inside you, baby. No, I ain't with the fake shit. What the 411 is, baby? It's all in for you. Just tell me what must I do? Yeah. You should come creative. This shit, salad. Like Bruce trying to see grinding. Yeah, this shit, salad.
Let's go. Yep. Let's go.
This shit feel like
Dream Team in full effect. DanaJay here. Shout out to everybody that's here. Oh yeah, we're gonna have some fun here. All right. Shout out to everybody that's here. What's going on, man? I don't got time to play around today. So I'm going to say Dream Team. Shout out to everybody that's here. I thank y'all for being here this morning. Y'all know how we doing it, and we doing it raw, uncut, and to the point. We finishing up paperwork from Judge Kruse, and then we're going to jump into Brian Steele's motions, and we're going to be here for a while. So we are going to cut out for a lunch break, and then we're going to come back, and we're going to go live. Well, I'm going to stay live. I'm going to stay live. I'm just going to give you a lunch break, and I'm thinking about, should I put one of my playlists up or not? I don't know yet, but I want to say shout out to everybody that's here. Y'all know is crazy hours for me. Shout out for the 18 people that's here watching. Hey, go tell your favorite blogger that their favorite blog is live. I always tell everybody that, because truth to be told, without me, there's no them. And without y'all, there's no me. So I want to thank everybody for being here and rocking with us and doing what y'all do. This is the DanaJay Show. I'm about to rebrand it. So this is the DanaJay Show. You're here live, uncut, direct. So we have a few formalities that we get out the way real quick. And the first formality is, if you look at the bottom of the chat box, there's a box with a $sign in it. It's called the Super Chat. If you want to donate to this channel, donate to the Super Chat. You can donate anything from $1 on up to $4,000. Nothing too great, nothing too small. DanaJay and the Dream Team, we approve it, and we thankful for it all. Also, shout out to everybody that's been hitting the Cash App. The Cash App is $OfficialDanaJay. That's for me and the channel. I split with the channel. But if you want to just, want me to get a lunch or something, just be like, yo, I need you to get a lunch just for your lunch or something like that. So cool. Also, I'm just running down real quick. Also, don't forget DanaJay's Patreon. Go sign up now. I'm telling you, because I'm loading starting today. And let me put people on point. I don't load my Patreon up every day because I have enough content in my Patreon that if I do it every day, you would never be caught up. So what I do is as of today, I'm going to load up every Thursday. So every Thursday, I'm going to put enough content in for the next week. And then I'm going to do it that way. And so that way y'all can be up to date and y'all don't got to worry about missing nothing. And especially if I just decide that I want to do a premiere or something, y'all won't miss nothing that's going on. What else? It's the Patreon. Okay. Next start Monday, I'm going to release my locals channel for everybody. Don't forget the DanaJay shoe line. If you want your shoes, go ahead
and email me at bookdanajay@gmail.com. So I can send you, a promo code to get some off. You know what I mean? To get something off. So I'm gonna send you a promo code to get something off. Also, I don't know what's going on. Also, if you are sustaining a slow response on your internet and computer, don't be alarmed. That's happening around the world, worldwide. Something is happening whereas though the internet and everything is being messed with. So don't be alarmed. That's worldwide. Also, don't forget Dana J on all my platforms. Official Dana J on all my platforms. What else? Okay, last thing. In September, starting September 1st, I'm going to be accepting donations to help me with my travel and my stay in Minnesota in December for the R. Kelly case. Okay? Just giving y'all a heads up, just letting y'all know what's going on. All right. Now we can get down to business. First things first, and before I get into the YSL and before I get into the Judge Kruse, I got a problem. And a problem that I have is and I think I'm gonna have a round table tomorrow about it. So if you know anybody that ever had anything positive or negative to say about R. Kelly, send them my way, because I'm gonna have a round table about it tomorrow. Time to bust up some lies about R. Kelly. Time to bust up some things that's not true about R. Kelly. Only thing I ask is that everybody be respectful to one another and listen to everybody. I don't know why I feel this urge to do this, but I got to do a round table or call in, whatever you want to call it. And we're going to discuss R. Kelly tomorrow night at 8 p.m. We definitely going to do that. But I got a problem. And the problem that I have is the media pick and chooses who they want to talk about and discuss. Now, something came to me early this morning, and I'm pissed with two S's, because we have a baseball player who I actually like watching because he was young, up and coming. But I didn't know Wander Franco was a pedophile. And from what I'm hearing, this is just the first story that came out about it. It's going to be another story come out where the government knew his background and they allowed him to come into the United States knowing what he was facing in his home country. So let's get into it. The Ball Alert, I give everybody their props. The Ball Alert posted Tampa Bay Rays star Wander Franco charged with sex trafficking after investigation found he paid a mother thousands of dollars to sleep with her daughter. Uh-oh. Y'all know how we get down over here. We don't like that. Written by at the fine author. Okay. Tampa Bay Rays star hashtag Wander Franco, and they hashtagged him. Oh God. Is being accused of sex trafficking just one day after he was indicted for sexually abusing a minor in the Dominican Republic. On Tuesday, the 23-year-old shortstop was charged with paying a 14-year-old's mother thousands of dollars to have a sexual relationship with her. This illicit arrangement reportedly lasted for 4 months. She has also been charged and remains on house arrest. On Wednesday, authorities in the Dominican Republic added additional charges to Franco's indictment, accusing the baseball player of illegal migrant smuggling and human trafficking. He was initially arrested in January 2024 in the Caribbean country following a 3-hour interview with authorities. However, the investigation had been underway since 2023, leading to Franco's being placed on administrative leave from the race. His last game was played on August the 12th, 2023. To read the rest log on theballeralert.com. Clickable link on the profile. And somebody put, now this is what should have happened to some of the parents in the R. Kelly case. Same thing, shaking my damn head. This is why I said I got to have this round table about R. Kelly. Because the first thing people do is throw stuff like this out. So we're going to discuss it all. So whether you friend, foe, whether I like you or not, if you got something to say, if you got something to add, tune in tomorrow. Only thing I say is just be respectful. And before I jump into this YSL, I'm going to do this real quick. If y'all haven't subscribed to my brother Chris Terry's YouTube page, go like, share, subscribe, and send to 5 people Chris Terry 2010 YouTube page. Support the music. It's getting down. And for y'all that don't know, I'm wearing a different kind of hat. I'm wearing a 444 Records hat, right? Let's just say this. I'm about to introduce some people to some real powerful people. Or should I say I'm about to introduce some persons into real powerful persons. Like I say, rolling with me come with perks. Let's go. Let's get this thing going. EJ said his live performance is fire. Oh yeah, it's crazy. It's hot. I posted it on both of my pages. It's hot. So let's go there. Oh. Let's go there. We talking about Judge Kruse first. Here we go. Judge Kruse, and we're going to open you up, sweetie. Here we go. I don't know, that's too big. Judge Kruse, this is the order denying motion to recuse Judge Kruse from hearing recusal motion. This case was randomly assigned to this court to consider certain motions to recuse Judge Glanville from other proceedings in the case. On July the 8th, 2024, defendant Jeffrey Williams filed a supplement to motion to recuse Judge Glanville, in which I will be reading after this. Williams docket 610. Though titled supplement, a portion of the filing seeks to recuse this court from hearing the recusal motions. This court, therefore, must consider the portion of the supplement seeking this court's recusal before proceeding further. USCR 25.3. Then the footnote says, when a judge assigned to a case is presented with a recusal motion and an accompanying affidavit, the judge shall temporarily cease to act upon the merits of the matter and determine immediately: 1, whether the motion is timely; 2, whether the affidavit is legally sufficient; and 3, whether the affidavit sets forth facts that, if approved, would warrant the assigned judge's recusal from the case. If all 3 criteria are met, another judge shall be assigned to hear the motion to recuse. On July the 9th, 2024, defendant Williams filed an amended supplement, Williams docket 611, to remove an assertion in footnote 2 from of the original supplement. Hold on. Mondi versus Magnolia, Advanced Materials Inc. case law. Internal quotations and citations omitted. See also USCR 25.3 Horn versus Shepard case law. Assessing whether these 3 criteria are met does not involve an exercise of discretion by the judge whose recusal is sought, but is a question of law to be determined by the assigned judge. See USCR 25-3, Mayor and Alderman of the City of Savannah versus Batson Cook Company case law. Defendant Williams' motion in footnote 2 and later a lengthy paragraph 52 asserts two bases for recusal of this court. Defendant Williams asserts that recusal is merited because of a $2,000 donation made by Judge Glanville to this court's recent re-election campaign. Oh my God. Oh my God. Here we go. Hey, G-Joy. Oh my God. So now we got another judge that's donating, huh? Okay. Defendant Williams also asserts that recusal is required because it is inappropriate for any judge to preside in any action where one of the parties holds a judicial office in any other court which sits in the same circuit. Facts. Defendant Williams' supplement seeking to recuse this court is supported by an affidavit, albeit only footnote 1 and paragraph 63 as to this court, and it was filed within 5 days of this court being assigned to handle the case. Therefore, the first two criteria are satisfied, and the only consideration for the court is whether Judge Glanville's campaign donation to this court's re-election campaign warrants recusal. The Georgia Supreme Court has held that the mere fact of a campaign contribution to a judge, even from a party to the case, does not warrant recusal where the contribution was not exceptionally large. Good versus state case law. See also Woodham versus Atlanta Dev case law. Then it says affirming denial of recusal motion based in part on a campaign contribution from one of the judge's colleagues on the court who had recused from the case. Post versus State 298 case law. Allegations of unexceptional campaign contributions or commonplace support during a judge's election campaign ordinarily are insufficient to require referring a recusal motion for reassignment to another judge. Hold on. Jesus Christ. The Code of Judicial Conduct reiterates this point, noting that when a campaign contribution is less than the maximum allowable contribution permitted by law, an affidavit seeking recusal must allege additional facts demonstrating the need for recusal. See Georgia RCJC Rule 211. In summary, Rule 211A4 provides that if contributions made to a judicial candidate or to that candidate's campaign committee are permitted by the law and do not exceed the maximum allowable contribution, then there's no mandatory requirement that the judge recuse. Hold on. Okay. ID. Because under Georgia law, I hate Mac sometimes. Because under Georgia law, the asserted campaign contribution would not warrant recusal, and defendant Kendrick has not alleged any additional facts demonstrating the need for recusal, he has not met the third criteria for recusal. Defendant Williams' additional assertion of Judicial Qualification Commission Opinion 220 in support of his motion and unavailing for two important reasons. First, Judge Glanville is neither a party nor counsel in this criminal prosecution. Hold on. That's not what we read last night. He is a party now. Nor is this a mandamus action. And defendant Williams cannot make it so by filing a recusal motion. So opinion 220's conclusion that a judge should not preside in an action campaign contribution limits are available at, and they have the ethics thing right there. It's a where one of the parties holds a judicial office in the same circuit does not apply to this does not apply to this circumstance. Second, and perhaps most importantly, Defendant Williams' motion ignores the clear directive of Uniform Superior Court Rule 25-4. That rule directs that in a multi-judge circuit, like the Atlanta Judicial Circuit, a recusal motion shall be assigned for hearing to another judge, and the selection shall be made by use of the circuit's existing random impartial case assigned method, USCR 25.4, emphasis added. This court does not relish the task to which it has been assigned, but it is as much the duty of a judge not to grant. Hold on. Let me put this, yeah. Judge not to grant the motion to recuse when the motion is legally insufficient, as it is to recuse when the motion is meritorious. Jones County versus a mining group, case law. Also see Hampton Island Founders versus Liberty Capital case law. For the foregoing reasons, the portion of Defendant Williams' supplement and amended supplement seeking to recuse this court is hereby denied. It is so ordered this 9th day of July 2024. Okay. So we got that out the way. But see, here's the problem that they're going to have. While they doing that and they thinking that they have everything in a pocket, check it. And here's the pocket. Here's the pocket. Even if the motion to recuse is not granted, it looks like they will prevail on appeal. Post versus State, a case litigated by Ashley Merchant and also cited by Brian Steele in his motion. So here's the case, Post versus State, right? And Ashley Merchant litigated this case and she won. So it says judge was required to recuse himself based on his oral statements, appearing to defend himself against motion to recuse. And then at 627, it say Ashley Merchant, the Merchant Law Firm, PC Marietta for appellant. And let's see. We're going to skip down to 62. Additionally, Judge Glanville must be recused automatically since he defended his position against Mr. Williams' motion to recuse filed on June 17, 2024. There it go. See YouTube dated July the 1st, 2024 at 2:38:39 through 2:51:15. Then they have the link. Then it says C.A.M. Hospitalities LLC et al. Versus Alan Shadani. Then it says this honorable court, Judge Kruse, must also be recused as she sits on the Fulton County Superior Court bench alongside of Judge Glanville, and 2, has accepted re-election campaign money from Judge Glanville, specifically receiving $2,000 in April 2024 from Judge Glanville. This occurred during Mr. Williams' current trial, which commenced on January the 4th, 2023, and is ongoing. I swear that the above is true and accurate. Bam. So Judge Glanville, he must recuse himself now, because not only did he defend his position, but he also giving money away. Let me check the comments, see what y'all saying. Georgia Girl said, hey, y'all. AG Tiffany. EJ said they're playing dirty as always, and the defense can get around it. Okay. That judge already made up his mind. I agree. Totally agree. So we about to get into our first lengthy paperwork. And this is very lengthy. And I mean lengthy. So this is Brian Steele. Paperwork that he submitted yesterday. The state of Georgia versus Jeffrey Williams et al. Indictment number. And this is for Judge Rachel Krause. This is what she did. This is the state's, it's not Brian Steele. This is the state's response to defendant's motion to recuse Chief Judge Earl Glanville. Oh, this is going to be interesting to hear this. State's response to defendant's motion to recuse Chief Judge Earl Glanville and the trial of the above style case. Introduction. Midway through this now months-long trial, defendant Jeffrey Williams and defendant Diamante Kendrick have each filed a motion to recuse Chief Judge Earl Glanville, hereinafter motions, and defendant has filed a supplement to the motions, hereinafter supplement. The state recognizes that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to the honorable to this honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the three requisite determinations. One, whether the motion was timely filed. Two, whether any affidavit made in support of the motion is legally sufficient. And three, whether if some or all of the facts set forth in the affidavit are true, recusal is authorized. This coming from the state? Ooh. Hold on. Hold on. Footnote. See Henderson versus State, 295 Georgia 333 2014. Recognizing that once a motion to recuse is filed with the trial judge whose recusal is sought, that judge must make three threshold determinations regarding the legal sufficiency of the motion, whether it was timely filed, whether the affidavit made in support of it is legally sufficient, and whether if some or all of the facts. Then it says, accordingly, it falls to this honorable court to make those determinations as set forth below, though defendant's motion and supplement are in part timely, and the affidavits in support of defendant's motion and supplement are in part legally sufficient. None of the facts set forth in the defendant's affidavits, even if assumed to be true, would authorize recusal. Defendant's motion and supplement should therefore both be denied. Wait a minute. Okay. Because on one hand, it's saying it should be denied, and the other hand is saying they want recusal. So the state don't even know what they want. Then say factual background. A, the calling of state's witness Kenneth Copeland on June the 7th. On June the 6th, 2024, in response to an inquiry from counsel from the defendants in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June the 7th, 2024. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment. Hold on. Oh, no. I see where this is going. So if Kenneth Copeland's lawyer contacted the state and told him to cease communication with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment. What did they lock him up for? See, here's the crazy part. You locked him up after his lawyer told you he's going to be asserting his Fifth Amendment. So you lock him up to scare him and to threaten him that this would happen again if you don't testify against Jeffrey Williams, aka Young Thug, aka King Slime, so that we can go ahead and prosecute him. Ooh, this is dirty. This is dirty. Then it says privilege if called to testify on June the 7th. Perplexing, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectively by Brian Steele and Max Shard. Melnick copied Brian Steele and Max Shard on his communication with the state regarding Mr. Copeland's intention not to testify. In preparation for trial, Deputy District Attorney Hilton, that's the one that they said got the stink vagina, allegedly, along with her investigator, had met with Mr. Copeland on multiple occasions. And at no time did Mr. Copeland state an intention to plead the Fifth or say that he was represented by Mr. Melnick. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7, 2024. We all know that's a lie. Woo, they lying on documents. Woo. Pursuant to OCGA 24-5-507, after receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granted immunity. Hold on, watch this. This is where they play on people's ignorance. So they locked him up to scare him after he pled the Fifth, then gave him immunity, and then boxed him in and said, if you don't testify, you're going back to jail until everybody in the trial case is over. That's coercion. Y'all just coerce Mr. Copeland to testify. That's coercion. And then you gave him a supplement to testify for, which is immunity. Then it says the state court issued an order granting the state's motion. So hold on. How can the state court issue a motion, right? I mean, issue an order granting state's motion if y'all didn't know what actually happened? Ooh, this is dirty. On June the 7th, 2024, after court was called to order, Mr. Melnick appeared before the court and informed the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination. In the presence of each defendant currently on trial and each of their respective attorneys, Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state has sought and been granted an order of the court pursuant to OCGA 24-5-507, directing Mr. Copeland to testify and extending immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland, in the presence of every defendant currently on trial and each of their respective attorneys, that should Mr. Copeland refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Hold on. Here's the problem. Where are their YouTube links proving what they're saying? There is none. So now if somebody want to go back and look, where would they go look? So this right here is insufficient, because if I was the judge overseeing this, there's no way that I will be able to look at this and say, okay, I'm going to deny it, but I don't see nothing to support what they're saying. Which means that when this was denied, when the a recusal was denied by Kruse, she showed her hand because she works pretty much for Judge Glanville. Or should I say under the guise of Judge Glanville. So it says, Mr. Copeland thereafter stated his intention to testify. And Mr. Melnick looked toward Mr. Steele and Mr. Shard and shrugged his shoulders. After motions hearing, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. Why should he have to? After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions. And when, footnotes, live, Young Thug, YSL, Rico trial. Okay. And then it says day 87 timestamps. Okay, so here's what I was looking for. But they should have put it in the body instead of the footnotes. Cheekly asked his age in years, Mr. Copeland, and responded, I plead the fifth. That's not how that went. Or when y'all asked Mr. Copeland, how old was he? He said, what? And then she said, well, Mr. Copeland, how old are you? He said, I'm grown. And she said, no, how old are you? And he said, old enough. And then she said, no, how old are you? He said, grown. And then she proceeded to ask him again, and he said, I plead the fifth. And then he was held in contempt. But that's after y'all had already threatened him that nobody has knew about. So it says the court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody in open court in the presence of all of the defendants currently on trial and in the presence of each defendant's respective attorneys. Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June the 10th, 2024, to allow Mr. Copeland to purge himself of this contempt by testifying. Hold on. I'm going to ask this question. And I'm going to go ahead and do this because I want y'all to read this. Can somebody tell me what this is called? And I'm going to give you some time. Matter of fact, I'm going to go ahead and hit the song. Can somebody tell me what this is called? Hey, Tiff, can somebody tell me what this is called? For the 25 people that's in here this early, can y'all tell me what this is called? It's a terminology that all of us use. So can you tell me what this is called? And the key part of it is right here. In open court, in the presence of all of the defendants currently on trial, and in the presence of each defendant's respective attorneys, Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back. So to lock somebody up and parade them in front of everybody, what is that called? And Teresa said double jeopardy. Nope. You close, but nope. This is called buck breaking. So pretty much Glanville has put his authority of saying, don't play with me in my court. You do what I say do. And if you don't do what I say, this is what happened. This is called buck breaking. This is the new age order of buck breaking. But Mr. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint standing counsel Caleb Bumpus to represent Mr. Copeland in court the following Monday. The June 10th, 2024 meeting regarding contempt proceedings initiated against Kenneth Copeland upon motion of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. What? On Monday morning, prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Kenneth Copeland. Kenneth Copeland, the court, and an attorney for the state to discuss the contempt proceedings initiated against Mr. Copeland upon the state's motion. Stop. Okay, because I'm about to say something. The court granted the state's request, and upon being directed to do so by the court. Now, hold on. The court asked for this, right? And it was granted. But they did it under file, under secrecy, because the defense ain't know nothing about it. So the court reporter made a record of the entire meeting, which means that Caleb Bumpkins can't get in trouble, because if a court reporter was in there, it's no longer private. It's a public meeting. It's just closed off. Present during the meeting were CDDA Love, attorney Caleb Bumpus, investigators for the state. Hold on. Look at that S on the end of that. Investigators for the state, and the Honorable Chief Judge Glanville, and later Kenneth Copeland and DDA Hilton. Now, hold on. Somebody lying somewhere, because Caleb Bumpus said it was 14 people in that room, right? Do anybody remember that? Caleb Bumpus said it was 14 people in that room. So let's count. 1, 2 investigators. Because there's an S on that, it's plural. So we don't know how many that was. We got 4, 5, 6. So if there's 14 people in there, right? That means they had 8. For that means they had 8 investigators. Why do you need all them people to talk to Woody, aka Mr. Kenneth Copeland, unless they were trying to scare him, which they tried to do, and which they did do? You know what I mean? So, and then they say matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland. If that's the case, Why wouldn't you let the defense be in there then? Somebody's lying. If they only discuss the contempt proceedings against Mr. Copeland, why wasn't the rest of the defense able to oversee it? I'll give you one better. If that's all you wanted to discuss, why did it have to be in secret? Why couldn't it be discussed in open court? If that's all you wanted to do, because y'all discussed a lot more worse than this in open court in this case. They could have sent the jurors back to the jury box. Back to the jury holding room, and they could have discussed this in open court. No, they didn't want it to go that way. They wanted to have a private assurance of a buck breaking, like, yeah, you gonna do this way. I ain't playing with you, boy. So then they say, and the topics addressed included topics Mr. Copeland's rights and representation as it relates to the proceedings. If that's the case, right, they forced Mr. Copeland to release Mr. Melnick because Mr. Melnick didn't do what they wanted him to do. He said he going on vacation, and he went on vacation. Well, if y'all remember, Glanville said, you ain't going nowhere because you belong here. And he said, my trip is already paid for. So Mr. Copeland's obligations under OCGA 245-507 and answers to questions posed by Mr. Copeland regarding matters related to OCGA 245-507, such as the distinction between oneself of contempt as addressed by OCGA 245-507 and perjury as prohibited by OCGA 245-507, with the exception of the times where Mr. Copeland was afforded an opportunity to speak with Ms. Bumpus alone. Hold on. But I thought y'all said that this was only about, hold on. Y'all said this was only about the topics of Mr. Copeland's rights and representation as it relates to the proceedings and Mr. Copeland's obligations under the Georgia State Code, right? So if that's the case, how y'all drop down not a whole sentence later and say, with the exception of the times where Mr. Copeland was afforded an opportunity to speak with Ms. Bumpers alone? So not only was y'all buck breaking him in Judge Glanville's office, which is illegal, y'all also was threatening and overseeing how much time he got to spend with his stand-in counsel, which is wrong. And then it says the entire meeting was taken down by the court reporter, which makes that meeting public. So then it says Brian Steele's defiance of the court's commands and subsequent contempt ruling. Hold on. He had that right to tell you or to not tell you where stuff come from. If it was nothing wrong, or if y'all wasn't doing nothing wrong, why did it matter how he found out? These are questions that Kruse should have been asking Glanville in open court. She should have brought Glanville in, and it should have been an open hearing, as Ashley Merchant said. So after the meeting regarding Mr. Copeland's contempt, but hold on, wait. You see how the state quickly got off of this. You see that, right? So it says, after the meeting regarding Mr. Copeland's contempt and obligations under OCGA 245507, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. I got a question to ask. Where did Brian Steele lie at? He called out everything that was going on. That's what a real trial lawyer is supposed to do. Anything that's misconduct or that can hurt his client, he's supposed to call it out in open court. That's the point of court. The problem is it's coming from one of their own. It's coming from Judge Glanville, which is supposed to be neutral. He ain't supposed to sway no way. So, most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's commands to reveal the Mr. Steele's source of information regarding in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court. How? You can't bully me, or you can't bully Mr. Steele into telling you my resources. The state don't get bullied by the judge to tell their resources, do they? Let's talk about it. When the state was trying to sleep with Young Thug family members and friends, Judge Glanville turned a blind eye. Come on. Fannie Willis sat quiet. And so did DA Love. So after the finally repeatedly disobeying the court and being held in contempt of court, Brian Steele filed the motion and supplement. Argument and citation of authority. No fact set forth in defendant's motion or supplement authorizes the recusal of Chief Judge Glanville. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bit of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case. Hold on. That's a lie. Because he had some extrajudicial source. When DA Love made herself part of the case and Judge Glanville was supposed to throw her off the case, he didn't do it because that would have shut the case down. A recusal should have came out then. But because it didn't, Judge Glanville felt compelled to continually do his Suge Knight activity in the courtroom. Am I saying it's right? No. Am I saying it's wrong? Well, based on the way I'm talking, y'all should know. So it says there's a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal. Present questions of law. Here, with the exception of the defendant Williams' untimely allegation regarding a single instance of where Mr. Steele was chided. Then they got footnotes down here. This is poorly written. Chided by the court for not being prepared. Defendant's motions and the supplement are based entirely on the defendant's assertions regarding the June 10th, 2024 meeting regarding the contempt proceedings against Kenneth Copeland. Now watch this. I told y'all that this should have been filed when it started happening. But because it wasn't, the judge and the state felt like that they can do whatever they want. And now that it was filed because of the last situation and with Kenneth Copeland, that was the that was the straw that broke the camel's back. Now they trying to say, oh, because of that, that's why they want to file this. No, it's not. It's an accumulation of things. And it says, meeting regarding the contempt proceedings against Kenneth Copeland and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated requests to provide the court with information. So I'm gonna ask a question. Why should he be required to give the court his information when y'all not doing the same thing? Then it says Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who is a legal interest in a proceeding or that person's lawyer the right to be heard according to law. So hold on. You're going to cite this. I'm starting to think the state's stupid because you want to cite this, and this clearly proves Bryant Steele's defense. This clearly proves Young Thug's defense and why they, oh my God. The state is proving that Bryant Steele is correct because it says Georgia Code of Judicial Conduct 2.9 and regarding ex parte communications provides that judges shall accord to every person who has a legal interest in a proceeding. So ask yourself this question. No, it says who has a legal interest in a proceeding. Then it says, or that lawyer or that person's lawyer, the right to be heard according to law. So I got a question. If you want to cite this, ask yourself this question. Was anybody on the defense side able to be in that meeting? Things that make you go, So if nobody from the defense side and was able to be in that meeting, how are they filing Georgia Code of Judicial Conduct? So it says, however, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland. How do they know that? So now they're assuming or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify. Since no defendant in this footnotes case law, in this case had a right to be present at the June 10th, 2024 in chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland. The fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted this 10th day of July. Adrian L. Love, Chief Deputy District Attorney. That's a lie. You can't hold an ex parte meeting about a sworn in witness without the defense being there. Exhibit A. Let's see. Here's a email from Jonathan Melnick to Hilton Simone, Adrian Love. Reason: Kenneth Copeland proposed bond order. Friday, June the 7th, 2024 at 11:56:16 a.m. It says, my concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go fuck yourself. Whoa. 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 Go F-U-C-K yourself if you think I'm doing anything besides protecting my client. On Friday, June the 7th, 2024 at 11:53:37 a.m. Eastern Standard Time, Love Adrian wrote, is your concern for your client or for Mr. Steele's and Mr. Shards? Oh, okay. I see where this is going. Is your concern for your client or for Mr. Steele's or Mr. Shards? If you want to go fast, go alone. If you want to go far, go together. African proverb. Why would they do this? Is what kills me. Now you putting African proverbs in, right? So now they trying to say that Mr. Melnick only cared for Mr. Steele and Mr. Shard's client. So what they actually telling you, and this is coming from Adrian Love, is that she don't care about nobody else's safety. Only thing she care about is getting a conviction. This is why I say what I say. Get the hell out of Fulton County until Courtney Kramer comes in office. And remember, I said that. Get the hell out of Fulton County until Courtney Kramer gets in office. We got to get Fannie Willis and her team out of there in November. So, subject, Kenneth Copeland proposed bond order. Then it says, hold on, where this coming from? Coming from Melnick. Here is a communication between myself and Ms. Love, which pertains directly to the YSL case. Uh-oh. Then it said forward message from Love. Okay. Good morning, Ms. Rosier. The state asks that the defendant be required to sign the conditions in front of a notary or a sheriff's official so that we can enforce the conditions upon his release, since he was not appraised by the court in person. What type of shenanigans they got going on? Hold on. He wasn't appraised by the court in person? Then why was he even in jail? Oh my God, bro. This is corrupt. From Jonathan Melnick, here are both proposed bond orders. Thank you all. John Melnick. Received. The court is awaiting Mr. Melnick's response. Thanks. Sheila Rosier, litigation manager. From Ms. Adrian Love on March the 1st. Ms. Rosier, please find attached the proposed bond order agreed to by the state and Mr. Melnick. I am attaching in Word format so that whoa. I am attaching in Word format. Why not PDF format? So now they can change the Word format. Oh. And like I said, I am attaching in Word format so that the court can revise where necessary. Like I said, the two orders have only one distinction. One contains the curfew provision that the court originally ordered, and the other does not. The state does not object to either, and Mr. Melnick asks that the curfew provision be removed. I have explained to Mr. Melnick that since the court originally ordered the curfew, the court must decide whether or not to keep it, other than the curfew. Mr. Melnick finds the proposed order acceptable. Please let us know the court's decision. As part of the order contains a requirement for the defendant's signature, acknowledging his understanding of all provisions and restrictions of the bond, and Mr. Melnick will visit Mr. Copeland to obtain his signature this week. Have a wonderful evening. Let's stop for a minute. Let's go back to a section. As part of the order contains a requirement for the defendant's signature, acknowledging his understanding, which means that he stand under their authority. That's why you see people that know how to place, people that know what's being said. You will never hear me say, I understand. You always will hear me say, I overstand. Because I don't stand under nobody's authority. So just the key words, acknowledging his understanding. If that wasn't changed, then guess what? They played legalese on him, which I said it from day one. So it says, good evening, John. I have attached a version of the bond order, both with and without the curfew, that the judge ordered. In order to facilitate, wait a minute, why would the judge order two bonds, one with a curfew and one without a curfew? But before I go any further, I have proven my case yet again. I told y'all there's no money in the United States. So how do the courts move with bonds? That's how they get paid. And I can give y'all the whole spiel on how they do it. But why would a judge order two bonds? Not unless you got it. He's getting paid from both bonds. So even if Mr. Melnick declines one, the judge still get paid for both. In order to facilitate the expeditious signing of an order, please present them both to your client. Like I said, please present them both to your client for his signature so that we can get an order signed, even if the court insists on her curfew restriction. Now watch this. Why do you need both of these signed just to get an order? Well, I'm going to tell you why. Because his signature is clearly saying that the judge is the one to receive everything and that he acknowledges that he's signing everything over to the judge. It's a hierarchy in this thing. And I think I'm going to show a video proving that probably on Monday. Exhibit B. This is the ex parte motion, right? Hold on, because I don't want to. Because I'm going to read this, so I don't want to read it twice. So I'm going to show y'all. I'm just showing y'all the exhibits. Yeah, because I don't want to read this twice, because I'm going to read this. Oh, hold on. I don't think I read this one. Hold on. I'm going back up, and we're going to read this. Hold on. Exhibit B, ex parte motion for order to compel testimony necessary to the public interest. I knew I was going to find it. Here we go. Pursuant to OCGA 245507, Georgia, by and through Fannie T. Willis, District Attorney of the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Adrian L. Love hereby moves this honorable court to compel a material witness, Kenneth Copeland, to provide testimony in the trial of the above style case. Further, in the event that said witness refuses to testify after being ordered to do so by this honorable court, the state moves this honorable court to hold said witness in contempt of court pursuant to OCGA 245507B and have said witness committed to the Fulton County Jail until such time as the witness purges himself of contempt by testifying as ordered by this honorable court. In support of this motion, the state shows this honorable court the following. On January 10th, 2015, Donovan Thomas Jr. was gunned down and murdered at 330 McDaniel Street in Atlanta, Georgia. Reginald Hendricks and 14-year-old Cordelia Saunders were also struck by bullets during the shooting. Wait a minute, 330 McDaniel Street? That's in Mechanicsville. No, bro, I can't see that. I can't see that. The Fulton County Medical Examiner's Office determined that Thomas Jr.'s cause of death was gunshot wounds to the torso and determined that his manner of death was homicide. Firearms evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down, 330 McDaniel Street in Atlanta, Georgia, revealed that a 7.62 rifle and at least one handgun were used in the murder of Thomas Jr. and the shooting of Hendricks and Saunders. Surveillance footage recovered from businesses in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Saunders were assailed by gunfire that originated from the sunroof and possibly window of a passing vehicle as the vehicle traveled west on McDaniel Street at around 7:22 p.m. on Sunday, January 10th, 2015. In the early morning hours following Thomas's death, Kenneth Copeland appeared at the Atlanta Police Department headquarters building and requested a meeting with police to report his whereabouts during the time of the murder and to report that his family was being targeted by people that, according to Copeland, apparently believed that Copeland was responsible for the murder of Thomas Jr. In the days and weeks and months following Thomas Jr.'s murder, Copeland gave 6 recorded statements to law enforcement, one of which was over 9 hours long, detailing Copeland's involvement with the criminal street gang YSL and statements of YSL co-conspirators about the involvement of YSL members in the murder of Thomas Jr. and other criminal activity. Copeland gave a detailed account of the events that led up to the murder of Thomas Jr., as well as his own involvement in said events, and of the events and acts committed by Copeland and other YSL members in the months following Thomas Jr.'s murder. Phone records of Copeland and other YSL members corroborated the statements that Copeland gave to the police. Statements made by YSL co-conspirators also corroborated the statements that Copeland gave to the police. Based in part upon the statements that Copeland gave to police, 5 YSL members were indicted for the murder of Donovan Thomas Jr., and 28 members of YSL were indicted for violation of a Racketeer Influence and Corrupt Organization Act. What did I tell you? What did I tell you? What did I tell you? This case is not about drugs. It's not about gangs. It's about nut. Which was Fannie Willis' old boo thing. That's what this case is about. It's about Peanut. In the judgment of the Honorable Fannie T. Willis, District Attorney of the Atlanta Judicial Circuit, the testimony of Kenneth Copeland is necessary to the public interest. See OCGA 245507. This is a lie because the public really don't want to hear the testimony. The public really want this case over with. So it says OCGA 245507 provides that whenever in the judgment of the Attorney General or any district attorney, the testimony of any person or the production of evidence of any kind by any person in any criminal proceedings before a court or grand jury is necessary to the public interest, the Attorney General or the district attorney may request in writing the Superior Court to order such person to testify or produce the evidence. Upon order of the court, such person shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required, but no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against a person in any proceedings or prosecution for a crime or offense concerning which he or she testified or produced evidence under the court order. However, such person may nevertheless be prosecuted or subjected to penalty or forfeiture of any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of the state. Key word, of this state. The United States or any other state. Hold on. I got a problem now. If this is what the immunity thing is about, they definitely did R. Kelly wrong. If this what the immunity bill states, that means they've been using evidence on R. Kelly from both jurisdictions, and they wasn't supposed to do it. Wow. Any order entered under this code section shall be entered of record in the minutes of the court, so as to afford a permanent record thereof, and any testimony given by a person pursuant to such order shall be transcribed and filed for permanent record in the office of the clerk of the court. Wow. B, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in the code section, such person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. Wow. If the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. Emphasis added. So it says Kenneth Copeland has been subpoenaed to testify in the above style case. Copeland is the next witness scheduled to testify in this case on June the 7th, 2024, beginning at 9 a.m. on June the 4th, 2024, and June the 5th, 2024. Investigators with the Office of the Fulton County District Attorney coordinated and arranged with Mr. Kenneth Copeland to provide Copeland transportation to court on Friday, June the 7th, 2024. However, on Thursday, June the 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the fifth in order to avoid testifying against members of YSL. Well, wait a minute. Let's go back. However, on Thursday, June the 6th, 2024, after an encounter with defense team members and members of the Fulton County District Attorney's Office. So therefore, it was an encounter between them two. They ain't talk about that. They ain't let that be known. So pursuant to OCGA 245504, Copeland shall not be excused on the basis of the privilege against self-incrimination from testifying or producing any evidence required, and no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against Copeland in any proceedings or prosecution for a crime or offense concerning which he or she testified or produced evidence under court order. However, Copeland may nevertheless be prosecuted or subjected to penalty of or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. Wow. Accordingly, the state of Georgia hereby moves this honorable court to direct material witness Kenneth Copeland. Oh, wait a minute. They transformed him from a person to direct material witness. Accordingly to the state of Georgia, hereby moves this honorable court to direct material witness Kenneth Copeland to testify in the trial of the above style case until released by this honorable court from the subpoena compelling said material witness to appear and testify before this honorable court. Further, should said witness refuse to testify after being granted immunity from prosecution pursuant to OCGA 245507 and order to testify pursuant to OCGA 245507, the state moves this honorable court to hold said material witness Kenneth Copeland in contempt of court and commit said witness to the Fulton County Jail until such time as the witness purges himself of contempt by testifying as ordered. Then it says, respectfully submitted this 7th day of June, 2024, Fannie T. Willis and Adrian Love. Look, I'm going to give everybody a 10-minute break, a 15-minute break. I'm sorry. Let's do a 15-minute break, and then we're going to come back and we're going to do another 20 pages. And it starts with Exhibit C. So let's take 15 minutes off, and then we're going to come back again and knock out another 20, 25 pages. But this is deep, though. This is real deep. All right. Be back.
When you feel like
you can't make it and you can't go on. When there's trouble all around you and your smile is gone, and when nothing seems to turn out just the way that it should be, you'll always have a friend in me. Through the good times and the bad, I'll be right by your side. You can call me in the morning or late at night. I'll be standing right beside you in your every time of need. You'll always have a friend in me. My love is unconditional. I'm here for you, through right or wrong. If you're in need, just call on me. I'll be right there. Your love to share. And what God has put together, no man can come between. You'll always have a friend in me. You'll always have a friend in me. Even late in the midnight hour, you'll always have a friend in me. When there's no one else around, have a friend in me. Every day and every night, have a friend. You will always have a friend. You'll always have a friend You will always have a friend in me. Yeah. Heavenly Father, I come to you right now to thank you for this opportunity. Thank you for health and strength and for bringing me here right now. And thank you for the chance to share this message with everybody. All right now. No, 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 no. Yeah, come on now. Yeah. Stop, take a look around. Look at all the things you have. Some don't even know the mother, and some have never seen their dad. Now my mama always told me, you may not have the things you want, but if you have the things you need, thank the Lord, don't give up and move on. Cause no matter what you're going through, from what you have, there's somebody doing worse than you. Cause there's always somebody worse off than you. Listen, some people don't know just how blessed they are to have someone to love in a world so cold and so dark. To you it might just seem like what you have is not enough. Take a good look at the news. Some people don't even have food. Somebody doing worse than you. Alright, thankful for what you have. The person doing that could be you. See, I wanna tell the world. Alright, thankful for what you have. Somebody say thank you, Lord. Yeah. No matter what you're going through, somebody gonna do something, yeah. It could be me or you. Worse than you, yeah. There's always somebody worse off than you. Yeah. For waking me up this morning, yeah. Thank you. I'm saying thank you, Lord. Yeah, just for my family and my friends. Yeah. Come on. Somebody works off me. Yeah. What you have, somebody somewhere worse off than you. Question is, will I ever leave you? The answer is no. Oh no. Oh no. No. Question is, will I ever leave you? The answer is no. Oh, I love the Lord, He so did me. Oh, He died that I might be free. I was asked this question years ago, and the answer is still no. Question is, will I do His will? And yeah, oh yeah. I was at home late one night. The Lord asked me would I do His will, and I told Him yeah. Yeah. I'm presenting my body, living sacrifice. All I want to do is a will of Christ. I was asked this question And the answer is yeah.
Now the question is, when will Jesus return? And the answer is, oh, he's coming soon, yeah. So. Listen here. Look at the trouble all over the world. He's coming to get every woman, man, boy, girl. Jesus is coming, yeah. Yeah. I can hardly wait for Jesus to return. For his return, my heart does yearn. I was asked this question, and the answer is real soon. Now the questions are, will I ever leave you? Will I do you? Will and when will Jesus return? Will I ever leave you? Will I do your will? When will Jesus return? And the answer, oh, soon. He's coming soon. Oh, yeah. You wonder when Christ is coming, the answer is real soon. Let me say it again. Now the questions are, will I believe you? Will I do your will? And will Jesus return? No. Yeah. It's coming soon. No. And it's real soon. Oh, yeah. First I told him no, then I told him yes, 'cause he's coming soon, so soon, yeah. And my answer is no. Yeah. Oh, yeah. He's coming soon. No. Yeah. He's coming soon. Better get ready. Oh no. Yeah. Soon. Yeah.
Yo, you don't get a lot of chances to meet special people in your life. But I'm just glad that I got the chance to meet these guys right here. Yo, Drill.
He's my homie. Never let you down or leave you lonely. He's got my back when other friends are phony. When you're down, don't hesitate to call my home back. He's my homie. Never let you down or leave you lonely. He's got my back when other friends are phony. When you're down, don't hesitate to call my home back. When other friends are phony and they never ever seem to have time, you can call my homie. 'Cause he's always around, with or without money. Unconditional, he'll love you still. He keeps it real all the time. When it comes to him, no one fits to be you. He's my homie. Ooh. Never let you down or leave you lonely. He's got my back when other friends are phony. Got my back. Let me say it one more time. He's my homie. Yeah. Never let you down or leave you lonely. Never let you down or leave you lonely. When you're down, don't hesitate to call my homie. When the devil's on your heels and there's no other way to shake him off, call on Jesus and he'll be right there. You don't have to worry, no. Cause no matter what, he'll always be around. He took away all my fears, dried my tears. Thank you, oh Lord, for your mercy. He's my homie. Never let you down or leave you lonely. Never let you down. The phony. When you're down, don't hesitate to call on him. Call on him. He's my homie.
No.
Never let you down or leave you lonely. Can I get a witness? Can I get a witness?
When you're down, don't hesitate to call my homie.
Help me sing it.
Like no other friend, he'll never let you down.
Let you down.
Like no other friend, he'll always be around.
He'll always be around. Yeah.
No. Everybody leave you alone. Yeah.
Sing it again.
No. Said you're my homie. Said you're my homie. Said you're my homie.
He's my homie. My friend, oh yeah. Do you believe it? Yeah. He's my homie. Never let you down or leave you lonely. Jesus. Come back when other friends are phony. Sing it again now. You down. Thank you, Lord, for your mercy. Like no other friend, you'll always be around. He's my homie. Let you down or leave you lonely. All right. He's got my back when
Said you're my homie. Said you're my homie. Said you're my homie. Don't you know that you're my homie? Yeah. All right, we back to it. Exhibit C. Everybody that's been away, let them know that we back. Run to my homie. Never let me down or leave you lonely. Now I'm back when other friends are phony. All right, we back. Exhibit C. Make sure everything is straight. Make sure everything's going good. Okay, everybody back. Where's that? Cool. Ooh, hold on. Hold on for a second, y'all. I was sending some paperwork off. Hold on. Let's see. Yep, they both went through. All right, let's kick it. Exhibit C. Let me see. 18 back in. Cool. Exhibit C. We got the order pursuant to OCGA. This is the order about the shall appear order and for Kenneth Copeland. And it shall not be excused on the basis of the privilege against self-incrimination from testifying. So this is what evidence required, however, no testimony given by Kenneth Copeland as required under his under this order. Hold on. Evidence required, however, no testimony given by Kenneth Copeland as required under this order or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under his or under this order shall be used against said Kenneth Copeland in any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Kenneth Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify. But didn't she just said in the last order that he shall not be subject to prosecution or penalty or forfeiture if he lied under oath? But then she come back and say he shall be subject. Like, yo, come on, bro. They playing games with him. They playing games with him. Hey, how y'all doing? Mama Mary, hey, what's going on? They playing games with him. Because the first order said shall not. Now this one say shall in bold underlined letters. If I was him, I wouldn't have signed nothing. Haradas, what's going on? This is crazy because I never seen a DA so corrupt that in one letter it says shall not be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify. But then in this one, the very next one, it says Kenneth Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing. They playing with him. So they lied to him. So wait a minute. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court of the state. This don't make sense. They gave him immunity, right, Teresa? But this is saying that he don't have immunity. This is weird. Finally, it is ordered that said Kenneth Copeland refused to testify after this order is entered. Said Kenneth Copeland shall be subject to being a judge in contempt of this court. And Glanville signed it. Like they all in this together. It's prepared by Adrian Love. Wow. Let's go to Exhibit D. Oh, the ex parte here. See, I don't want to read this because I'm gonna read it all in its entirety. Oh man, like they really playing. But let's read this part. See, because they want to make themselves look good. So let's read this part. Ex parte hearing began at 9:10 a.m. present in chambers where Judge Glanville, Assistant District Attorney Adrian Love, and Attorney Kayla Bumpus, court reporter Christian Weaver, and investigators Antonio Lang and Rasheed Hamilton. Hold on. That don't sound like 14 people. Let's count. Judge Glanville, 1. Assistant DA Adrian Love, 2. Kayla Bumpus, 3. Court reporter Christian Weaver, 4. And 2 investigators, 5 and 6. And we're going to add Woody, 7. So where's the other 7 people that they not putting in this affidavit? And see what I'm saying? That's why Woody was saying, it's not all in there. It makes sense now. So the court reporter, okay, I'm ready whenever you are. Ms. Love, thank you. The concern that we wanted to bring to the court's attention as the state was twofold. 1, we wanted to have the opportunity to impress upon Mr. Copeland with representation present that he faces blank. Why is it redacted? Oh my God, man. There's no transparency nowhere. Why is it redacted? And we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was sort of blank. We had to pull him in the courtroom when the jury came out. What? That don't even make sense. The second concern that I have is, and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday. I don't know what advice counsel may have offered or may be offering. That is their right and their business as it relates to testifying. However, I do not believe that criminal exposure is a concern that is blank, which interest is being spoken about and protected. Mr. Melnick relayed to Ms. Hilton on Friday that he had never heard of the statute 245507. And on Friday, he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shard. I don't know if he unintentionally put my name on it, but he sent an email to Mr. Steele and Mr. Shard with me and Simone copied, where he said, this is the communication that I received from Ms. Love regarding Mr. Copeland. Hold on. We all just looked at that. She lying. Because that was directed to Ms. Love and to Ms. Hilton and Mr. Steele and Mr. Shard and was CC'd on it. See how they lie and they switch it around? That was a lie. My response was, whose interest, who's this saying, who's this right here? Saying my response was, who is that? Whose interest are you protecting? Oh, okay, Ms. Love, yours or Mr. Steele's? Blank, whose clients blank, which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shard's? Well, that's two different things right here. So if this is Miss Love in response, why did she lie right here in your face? Because she said, whose interests are you protecting? Yours or Mr. Steele's? Then they go blank. Whose clients? Blank. Which client are you protecting? Whose client? Yours or Mr. Steele's and Mr. Shard's? That's two different sentences. And that's two different terms. Because Mr. Shard wasn't put into the above sentence. So if you're trying to say it twice, you're lying, because one is a lie and one is a truth. Just by you leaving somebody out makes you a lie. Or should I say, it makes you not telling the whole truth. He wrote back and said, you are going to get him killed. You have made him blank. You have made him a target. You are making him a target. Okay. You have made him blank. You are making him a target. F you is what he wrote in the email. So given that his concern is that by testifying, at least the one that he conveyed to me in writing, it's not blank. His concern has nothing to do with exposure from the state. If this is not telling people, please listen, man. If y'all going to go testify for the state, understand the state don't give a hell about you. They just want their conviction. And then she say, and if his concern blank, the court, his being whose concern? Ms. Love, Mr. Melnick, if the interest that he is protecting is Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. In fact, if he's concerned that testifying will get Mr. Copeland killed and he is not communicating with us, he's communicating with counsel for defendants. It would seem that he knows a thing or something that we don't know. Additionally, and I will let Ms. Bumpers tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland, which is strange because if your interest is your client, then it would seem you would want to be there for him while he's testifying. No, because evidently his lawyer told him, don't sign nothing, don't say nothing, plead the fifth. So that way you won't be caught up in no crazy mess. And what happened, the way it looked, is that they scared him by locking him back up and taking him away from his family, because you know that's what he loved is his family, his kids, his offspring. So when they locked him up and took him away from his family, he was like, man, I'm gonna just do what they asked me to do. But then he went nuclear and told him he made all of it up. So yeah, I understand Mr. Melnick's point. If I told my client to do something and you did something else, man, but that means that you don't trust my judgment. So how can I represent you? I swear I should have been a lawyer. I should have been a lawyer. Then the court said, well, Judge Glanville, which is the court, said, well, he is on vacation this week. Ms. Love said, I understand. That is why he has Ms. Bumpers here. And he has said what he has said. Ooh. Ooh. Such attitude. Hey, Galatians 6:7. And as I was reading the statute, the thing that is blank, and I was reading the statute about this particular situation, and I was reading our rules, our ethics rules, rules of conduct for attorneys, and it is clear that if an attorney blank, there were two things that were happening. One, Mr. Melnick had told me that he wasn't Mr. Copeland's lawyer. That's a lie. Mr. Copeland had told Ms. Hilton that Mr. Melnick wasn't representing him. And then rather than Mr. Copeland reaching out to Mr. Melnick apparently was in communication with Mr. Steele and Mr. Shard, and Mr. Melnick reaches out to Mr. Copeland and injects himself in these proceedings. I'm lost. Didn't we read before we went on that small break that Ms. Love sent the bond proposals over to Mr. Melnick for Mr. Copeland? I need y'all in the chat to help me. Didn't I just read that and show that? But now she come back and say that Mr. Melnick is not his lawyer. So if that's the case, then hold on. Because now we got all type of ethnic things going on. Here's the problem, Ms. Judd. If they knew that Mr. Melnick wasn't Mr. Copeland's lawyer, why would you send the bond offers over to Mr. Melnick for Mr. Copeland? That means you are exposing Mr. Copeland to unspecified attorneys. And nobody see nothing wrong with this. This is a whole shit show. And nobody see nothing wrong with this. Then she say, what we were discussing was in no way a matter that Mr. Melnick was representing Mr. Copeland on. And that is where we are not allowed to speak with a person when they are represented by counsel. Mr. Melnick could not have been representing Mr. Copeland on anything we were talking about, because we were talking about this case and this trial. But wait a minute. You sent Mr. Melnick the bond offers for this. So then it says, all that aside, we would like an opportunity for the court to address Mr. Copeland and Mr. Copeland's stand in counsel present, Ms. Bumpus. But Ms. Bumpus is only there because Mr. Melnick is out of town. What the hell? This is like come on, man. The only reason why Ms. Bumpus is there is because she did a favor for Mr. Melnick, because Mr. Melnick was out of town. So if Mr. Melnick is not representing Mr. Copeland, why the hell is Ms. Bumpus there then? These are problems that's in a court system, and this is why they didn't want this out. Because people like me is going to pick this apart piece by piece. So it says, all that aside, it say, we would like the opportunity for the court to address Mr. Copeland with Mr. Copeland's stand-in counsel present. Ms. Bumpus is looking at me like blank. Ms. Bumpus, I'm listening. So evidently there's some hostility there because somebody's lying. Ms. Love, with his stand-in counsel present, and to allow Ms. Bumpus an opportunity to explain to Mr. Copeland everything that I have just said. Her concern outside was what is the longest he can stay in jail. What I relayed to her is the statute says until he purges blank. That don't even make sense. Why would Ms. Bumpus ask what's the longest he can stay in jail? That don't even make sense. And see, and stuff like this will make me really go nuclear and go beyond the scene. The court by testifying. Ms. Love, blank his contempt by testifying. The court, yeah, 507 is a little bit different. So, I mean, Ms. Bumpus, so until the end of this. The court, he can be here until the end of the trial. Ms. Bumpers, that is what I said. To the end of the trial is the longest. Ms. Love, no, it's not the longest. Even after a grand jury blank, if a person has been subpoenaed to testify before the grand jury, and even after the grand jury has blanked, what is it? Convene, has left. That person can stay until that person purges himself or contempt by testifying. The statute literally says that. Ms. Bumpers, well, I'm going to look it up because it was my understanding that it was until the end of trial. Ms. Love, nope, Here it is. Literally, the words of the statute, and so blank. The court. He could be in there a while. Let's put it that way. Either way. Why is Judge Glanville in this meeting? I keep saying it over and over and over again. The powers that be is putting us colored folks in place to make an ass out of ourselves. And we doing a great job by doing it. So then it says, Ms. Bumper said, I just want to be able to give him blank. The court, I know. It's kind of the statute. It's kind of the statute says, that you purge, but I can't keep him here. I can't keep him in there indefinitely. I've got to kind of blank. Ms. Bumper's right. That is all I want to know. The court, the whole thing is that he can blank. He has the keys to his own freedom. And that freedom is if he just gives his testimony, then he's purged it. Ms. Bumpers, right. Ms. Love, and whether that testimony, and whatever that testimony is, we know what we believe it to be, but we don't know what it is. We can't talk about it. We don't. Blank. I mean, we don't know what he's going to say. We have an idea. We know what he's told us. Hold on. So if you know what he's told y'all, why do you need him to come testify? Because when I last recalled, Ms. Love and that other lady said that they haven't talked to him until court time. Ms. Bumpers, yeah, Ms. Love. And our concern is that if he is blank, our concern blank, I know the court said essentially you intimidated that you blank. You intimated that you blank, that Mr. Melnick probably told him essentially you should testify. They are not going to blank. They can't do anything with your testimony. But what we overheard being said was they are going to hammer you as if we were going to expose Kenneth Copeland to blank. Ms. Bumpers, you heard that? Ms. Love, yes. Yeah. Mr. Melnick told Mr. Copeland we're going to hammer him. The court. Now, to be fair, and I think Ms. Bumpers as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination. Stop for a second. This is all I needed right here. Now, let me break this down. If Ms. Love said she overheard it, right? Hold on. Ms. Love says she overheard it, but she was nowhere near Mr. Melnick and Kenneth Copeland. Why the judge or why Judge Glanville ain't hammer Ms. Love about where she got that personal business from? because that was a personal conversation between Mr. Melnick and Mr. Copeland. Now, if we're going to go fair, let's go fair. Why Miss Love wasn't charged with contempt? Why wasn't she scolded in the same way Brian Steele was scolded about where did you get the information from? So is your chambers any more greater to have a private public conversation versus a lawyer and his client to have a private conversation? Make it make sense. Hey, Galatians, can you send me that Willie Lynch letter? I got to get a copy of that, please. Now, instead of him holding her in contempt, he says, now to be fair, and I think Ms. Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination. Ms. Bumpus said, yeah, I think that's what he meant. The court, I mean, he's going to face blank. He's got about 10 blank. Ms. Love, so he meant the defense is going to hammer him? Ms. Bumpus, no. Just in general, he's going to be blank. It's not going to be hey, da. Excuse me, Ms. Love, he knew that. He had already been expressing that. The judge, Glanville. But I mean, I think that if he's concerned about that, well, but blank, it's all in the message and the packaging in terms of, I think Mr. Copeland is, a savvy person, but, he's certainly going to be subject to a thorough and sifting cross-examination. Ms. Love. And the other thing is that blank, Ms. Bumpus, can I just say something in Attorney Melnick's defense and response, just for the record? Ms. Love, yes. The reason that he doesn't want to move forward with representation, what I have been told, if he decides to testify, is that he doesn't feel like he can blank. He doesn't know what was said outside of his presence. So he doesn't feel like he can adequately represent him or counsel him because he doesn't know what was told to the state when he wasn't there. That's fair. Ms. Love said, but the thing is that the only thing that he should be concerned about is the criminal exposure or the exposure that Kenneth Copeland has criminally, and there is nothing. So Ms. Love is trying to defer. She's trying to deflect. There is literally nothing. The statute is quite clear that we can do to him about blank. The only thing that will put him in harm's way is a lie and a refusal to testify after being ordered to do so by the court. And by a lie, we don't mean like, oh, I think you lying. It will have to be, something obvious, because we can always impeach. But if he literally perjures himself, that's something different. We can't help that. We can't control that. We will only say, tell the truth. I don't care how bad it is. Just tell the truth. So, like he says, I didn't go down to the police station, the court, the judgment. And I think part of his challenge, Ms. Bumpus, may be that you need to assure him, look, I'm going to be here. So now they teaming up against Ms. Bumpus about Woody. And if you think that they are asking you a question, they being the state or the defense is asking you a question that's going to bring out other crimes that you're going to blank, he's going to be able to look to you and say, can I have a chance to talk with you? Ms. Love, that's exactly right. Ms. Bumpus, Ms. Love, see, but that's just it. Ms. Bumpus, no, he's not. Hold on. This is not making sense. Ms. Love, that's exactly right. Ms. Bumpus, Ms. Love, see, but that's just it. Ms. Bumpus, no, he's not. Thank you so much, but it's not making sense. Ms. Love, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing blank, and I'm not talking about you. Ms. Bumpus, yeah. Ms. Love, there's been an assertion that people are representing his blank, that their biggest concern is his best interest, and then they are just not here. And Ms. Bumpus is saying she's not in position to do that. Ms. Bumpus, no, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and Melnick, who I'm standing in for, is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges Melnick as his rep. I knew it. So Judge Glanville and Ms. Love is trying to get them to discharge Ms. Melnick because Melnick is not agreeing with what they're doing. This is dirty. That's their agreement. I can't do nothing about that. Ms. Love, that sounds weird. That does not sound like something in Mr. Copeland's best interest. That sounds like protecting somebody else's best interest. If you talk, I can't blank. I ain't going to blank. I'm not going to represent you. I don't even know what to do with that. Ms. Bumpus, well, he said he does not know what was said. Ms. Love, it doesn't matter what was said. Ms. Bumpus, right. Ms. Love, it doesn't matter. Hold on. How you going to tell? Wait a minute, bro. How you going to tell somebody lawyer that's absent it don't matter what was said? So Ms. Love said it doesn't matter, and he didn't ask us. He didn't even inquire. What have you all talked about? He has been talking to Brian Steele and Max Shard. That's it. He is not talking to us. And in fact, when Mr. Copeland asked to speak with us, Mr. Melnick barges in and gets in between Ms. Hilton and Mr. Copeland and literally keeps us from talking to him before he gets called to the stand. And that's troubling. Ms. Bumpus, well, I think what happened was blank. And I say this because I previously represented Mr. Copeland previously on his other stuff. So I know when he blanked, this is just what I think happened. I think how Attorney Melnick came involved was his representation of other blank because he took my place. Copeland fired me and hired Melnick. And then this came about. And I think so at the beginning, Melnick was representing him and then blank. There you go right there. There you go. So the state is trying to make Woody fire Mr. Melnick as well. Ms. Love said in his criminal matter that he had, but that's resolved. Ms. Bumpus, but when this case started, Melnick called me and told me that he was representing him as a witness at the beginning. I can assert that. Ms. Love, Melnick has never in life blank. Ms. Bumpus, this is 2 years ago. Ms. Love, Melnick didn't blank. As a matter of fact, less than 2 years ago, when Copeland was sitting in jail for something else he had done, Melnick said, I don't represent him. He told me, I don't represent him. And people were in the room. He was on speaker. Ooh. 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 So not only do Fannie Willis do it, but Ms. Love do it. So that means that whole team is doing it. You can't do that. You can't record or have other people listening to attorney calls. Oh, wow. This is crazy. She said he was on speaker. He told me he didn't represent him. Now he ultimately did come about and represent him. But when we were trying to get, I guess, blank, Ms. Bumper says something, yeah. This stuff is heavily redacted because the sentences don't even make sense. Ms. Love, Copeland was like, he's not my lawyer. I don't have a lawyer. He's not my lawyer. And then blank. Ms. Bumpers, are you talking about recently? Ms. Love, so recently Copeland said that Melnick was not his lawyer. Bumpers, right. Ms. Love, when Copeland was in jail, Melnick told me he wasn't his lawyer. But our understanding was that Melnick was his lawyer for those criminal charges. And so the person that came in and argued or at least stood in for him on his bond and then on his subsequent plea was Melnick. But I don't know whose interests he would be representing when he's not talking to us about what we've spoken to Copeland about. He could ask us and we would tell him, you know. So I don't know why he would withdraw his representation of him. If his interest is Kenneth Copeland, then why would you pull out? Blank, because he don't trust y'all. This is crazy. Miss Mama Mary, I agree. Aisha Judd, I say the same thing. Wow. Okay, cool, Galatians. This is not making sense to me. Hold on. My bad, y'all. I don't know why it went out like that. So the judge said that doesn't make sense, Ms. Love. Blank. At the point where he would face the most peril, if that is his concern. If his concern is, I don't know what they talked about, so I don't know what. Blank. The judge said, and I thought that Ms. Hilton had a list of questions for Mr. Copeland anyway. Ms. Love, she did. The court, well, how come you all can't blank? Ms. Love, he didn't ask to see those. He didn't blank. And not only that, blank. The court, well, can't you all share that with Ms. Bumpers? Ms. Love, well, Ms. Hilton has already shared it with Mr. Copeland, and we certainly will share it, generally speaking. What? Ms. Bumpers, can I read this email that Melnick sent me? I don't know if this will help you understand what he's saying. It says, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the fifth. He may change his mind on Monday. If he does, then he's agreed to discharge me as his attorney. This isn't out of bad feelings, but I was not present when he met with the DA's office, so I can't really help him with his testimony. And then he gave me the discharge and told me that if he decides to testify, then he's to sign this. Ms. Love, and that's just it. It's like you never know what somebody is going to ask. And if he's concerned about putting him in legal jeopardy, then he blank, it would seem like he would remain and allow Mr. Copeland access to counsel when Mr. Copeland is concerned that he's about to walk into an area that puts him in legal jeopardy. Ms. Bumpers, you can't switch how he gets called. Ooh. 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 Ms. Love, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. Oh, boy. So now we see how Ms. Love is working with the judge and the state, and they all working for Fannie. Now that makes sense. Because Ms. Bumpus said, you can't switch how he gets called. Ms. Love said, see, that's not in Mr. Copeland's best interest. That's in the defendant's best interest. When you say switch and how he gets called, what does that have to do with anything, Ms. Bumpus? I don't know. Maybe he's saying he can't do it because he can't get his refundable ticket. Ms. Love, that is not what he said in that email to you. And that is not what he relayed to the court. And his concerns have nothing to do with blank. The judge, he was very much blank. Ms. Bumpus, I tried to go back and watch as much as I could. The court or the judge, blank telling me what he was blank, that he was going on vacation. And I said, well, you inserted yourself in this. I said, really? You need to come on Monday. But nothing was done to him, though. Ms. Love, so he can't force Mr. Copeland to discharge him just because Mr. Copeland decides to testify. The judge, I think you are in until it's done. I mean, you know, blank. Ms. Bumper said, who, me? The judge said, yeah, I mean, that's just blank. If he testifies, you've got to kind of blank. Ms. Love, and frankly, Your Honor, I know that if a person faces criminal contempt, they are entitled to representation if they want it. This being a civil contempt matter. Blank. The judge said, not necessarily. Anybody who's facing contempt can get counsel. I mean, you know, not anybody but blank. Ms. Bumpus, I can't stay. How long is this going to take? Ms. Love, it may take some days. Ms. Bumpus, Ms. Love, and see, that's just it. And I don't mean blank. I think Ms. Bumpus is put in a precarious position. She's not the one that stood up and injected herself into this. They reached out to her and she did him a favor. But ultimately, it seems as if Mr. Melnick is stalling and attempting to delay and hamper and hinder our proceedings. And that is a problem, because that has nothing to do with the best interest of Kenneth Copeland. And that has nothing to do with Kenneth Copeland's exposure if he testifies. Just to answer the question about what he is exposed to, the statute is very, very clear. It literally says that no testimony or any evidence required under the court's order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense concerning which he testified or produces evidence under the court order. But wait a minute. Didn't I just read that it shall? So Ms. Bumpus is sitting there while the judge and Ms. Love is bouncing back different things against Ms. Bumpus. Then she had the nerve to say, that is saying even if he got on the stand and said blank. The judge said he started talking about an unrelated crime, which is what the biggest thing I think he's probably thinking about is that, yeah, there's a lot of stuff they could ask me about blank. Ms. Love, right, the court, blank. That is not known to a lot of people, and that blank, you know, he could also invoke his Fifth Amendment with the advice of counsel if it was some other particular crime, but blank. So the judge is even saying that he can do it. So they came up together to make sure he don't do it. Ms. Love said, but even that, we wouldn't blank the court, but the judge, which is the court, even that he'll still have to testify. Ms. Love, literally blank, right. The saw lays blank. The court, yeah, I mean, anything he testifies to, blank. Ms. Love, blank, we do this. Ms. Bumpers, okay. And then about the delay or stall, isn't it true or is it not true that he had a leave filed since December? Ms. Love, we have nothing to do with any of that. He injected himself into this. The judge, yeah. See, the problem is blank. Ms. Love, he stepped in. The court, blank, that when you get involved, I don't know you have a leave, blank. Ms. Love, right. You blank. The judge, blank. And unless you filed that leave into this case, you don't have a leave for my case. Wow. Ms. Love, right. Ms. Bumpers, okay. So Ms. Bumpers just playing it cool. And he did not. The court said, or the judge of the court, so he didn't have one. Ms. Love, Mr. Copeland been a witness and a name on this witness list since blank. The court, so since he said, well, I represent him, I'm like, okay, well, you don't have a leave. That's filed in our case. Ms. Bumpers, okay. Man, how much? This is brutal. Ms. Love, so he did this to himself and he did it to you. But we have to blank, That is just where it is. And I don't know that. Blank. That's just where we are. The question is, who's we? That's where who are. So Ms. Love is indirectly telling you that they all working together. Ms. Bumpers, so judge, you are going to make me stay if he chooses to testify? The judge said, I am because he blank, you're his lawyer. You're a standing lawyer at this point. Ms. Bumpers, Your Honor, I don't have a problem with that. I just blank, I'm not ready. Ms. Love, if blank. The judge said, there's nothing for you to be ready about. I mean, here's the thing. I think the only thing you've got to kind of ask him about is, look, here is the questions the state is going to ask you. Wait a minute. The state ain't supposed to show. Oh my God, Jesus Christ. All right. Is there anything else that could hurt you that they might ask you about? And as long as you have knowledge of that, then I think that you are fine because the state's only going to get into this. Now, the reason you want to know what's going to hurt you is the defendants know more about Kenneth Copeland than anybody else. So they are probably going to kind of blank. So Ms. Love and Judge Glanville is trying to get Caleb Bumpus to be on their side against Mr. Melnick. This is beyond crazy to me. Hit that like button, y'all. This is beyond crazy to me. Ms. Bumpus, what about if I say I can't do it? Then Melnick needs to come back, right? I am going to be in trouble because I was only for Monday. That's what I was told. I was given specific. Ms. Love, if Copeland said blank, I don't know what Mr. Copeland wants. It's his choice. Ms. Bumpus, can't he say he doesn't want Melnick? Ms. Love, he can say whatever he wants. It's his choice. Ms. Bumpus, but the judge is saying blank. Ms. Love, I don't think he can be forced to have representation if he doesn't want, need, or say he wants it. Because we have offered blank. We have done everything to clear him of judicial exposure. He's not blank. There is nothing he can say blank. He could lie. That puts him in, blank. And the court, Pearl. Ms. Love, blank Pearl. But you know, he can't talk about a crime that we could then prosecute him for, the judge or the court, that is involved in this or some other place. Ms. Love, right. Ms. Bumpers, I understand that, blank. This is crazy. This is crazy and it's brutal. Ms. Love, and we can't use his testimony to go find evidence to prosecute him for the stuff he talks about. Basically, he is literally shielded. Ms. Bumpers, I would have to agree with you that I don't think that that's the concern. Isn't that what you said? Ms. Love, well, the courts said that blank. That well right there done put her on notice. Ms. Bumpers, no. I'm saying with Mr. Copeland not testifying. You said you don't think that his concern is criminal exposure, or you do think that is what he's worried about. This is bad. This is bad. This is the greatest shit show on earth. I ain't gonna lie to you. This is worse than the O.J. Simpson commercial. Or the O.J. Simpson trial. I say commercial. This is worse than the O.J. Simpson trial. The court, do you think that he's fearful of testifying for other reasons? Like for his personal safety? Ms. Bump is right. Ms. Love, that is what Mr. Melnick said to me in an email. I can pull it up. He said, Ms. Bumpers, but you don't believe that, blank. Ms. Love, blank. You are going to get him killed. That's what he said. We ain't going to kill him. Ms. Bumpers, see, I don't know anything about that email. Ms. Love, we ain't going to kill him. I can show you the email, but we're not going to kill Kenneth Copeland. So who is he talking about? So what are you trying to do? The judge said that is a collateral, second and third order effect. You know, let's pray it doesn't happen, but blank. Hold on. Do y'all understand what the judge just said? He pretty much said that Kenneth Copeland is nothing more than collateral. You are expendable. You are nothing to us. We're going to use you to get what we want. That's pretty much what he said. And then he said, in the process of you being used by us, we hopefully pray that you don't get offed or nothing happened to you. And then he put but behind it. And then Ms. Love followed up and said, I mean, obviously he blank. Wow. This shows you what the court feel about you. So they know that anything that go against Thug or anything that go against the others, they saying that he can possibly get killed for that. And they don't care. It's sad. Ms. Love, I mean, obviously he, blank, the court, which is the judge, blank first, he has to give testimony though. I mean, that's what he has to do. He's got to give the testimony, whatever it is, good, bad, or indifferent. Good, bad, or indifferent, I should say. Ms. Love, so we would like, with the court's permission, blank, they haven't brought him over. And he was supposed to be the first one up. So I guess they went to get him. They might be over here with him now. This is what I'm going to do. I'm at 46 and we got to go to 81. Y'all go ahead and grab some lunch or something. I'm going to take it's 2:37. I'll be back here at 3:37. I'm gonna go grab something for lunch, and we're gonna finish this thing out. But I'm not taking it off. We're gonna keep it on the screen. Because this is crazy. Like, this is real crazy. I mean, like, next level crazy. I'm just saying. Good God Almighty. See y'all lunchtime. After lunch, I meant at 3:37. But this is really sad. See y'all at 3:37.
I don't think I can do this anymore, baby.
Why not?
Oh yeah, girl.
Oh yeah, girl.
I never meant to hurt you, babe. It's all I've ever heard you say. Too many times it's been the same. You can stop it with your crying games. No matter how the time goes by, I look at you and it always reminds me I'm sorry doesn't change that fact. So I guess it's just gonna have to be like that.
Wish I had some magic powers to somehow undo what's been done and what's been said between me and you. Love, I wish I had the power.
Yes, I do.
I can't undo all the wrong and the hurt between me and you.
Sometimes we say things that we don't really mean. If I could change the end of time, girl, that would be my dream. We belong together, even though we had hard times. I'm sorry for the pain I've caused you. I must have been out of my mind. Ooh, abracadabra.
Wish I had some magic power.
Yes, I do.
To somehow undo
To undo
what's been done and what's been said
what's been
between
done
me
and
and
said
you.
between me and
Love, I wish I had the power. I can't undo all the wrong and the hurt between me and you.
Can't keep myself from remembering.
No.
I do the spells to make them better. Disappear. I've even wished I could have a little better.
Baby, could have been
Nothing can
better.
change the pain you got.
Nothing can change it, baby.
Only word to say is goodbye.
Goodbye.
What's been done, what's been said, Love, I wish I had the power, the power. I can't undo all the wrong and the hurt between me and you.
Boom, boom, boom. That's the first song that I ever heard that Keith Sweat ain't never cried on. Oh my God. That's the first song that I ever heard that Keith Sweat ain't cry on. Man, he didn't cry. So let's get back into it. Let's go, y'all. The court, is he here now? Miss Love, I don't know. Judge Glanville exited chambers at 9:33 a.m. So what y'all really realizing is that Judge Glanville lied, because he said at 9:33, Woody was in his chambers. Now, my question is, at 9:33, if Woody is in your chambers, how is it that Miss Love don't know and you walked away? That's my question. How is it that Miss Love don't know and that you walked away? That's all I want to know. Can somebody explain that to me? How is it that Miss Love don't know and you exited your chambers? Let me say the right words. You exited your chambers. Okay? Hold on for a second. So I'm just trying to figure out, when did Woody enter the chambers if you telling me and you told everybody else that Woody was there at 9:33, and we are reading that Judge Glanville exited chambers at 9:33 a.m. Ms. Love said, we would like to just go into another courtroom and talk to him. Uh-oh. My question is, hey, Willie, hey, my man, why do you want to go into another courtroom and talk to him? Why not stay in the chambers? But for the damage is already done. So Ms. Love said, we would like to just go into another courtroom and talk to him, give you a chance to talk to him, and then give you an opportunity to explain to him blank. The court reporter said, we're off the record. Brief recess. Judge Glanville and Mr. Chamberlain entered chambers at 9:34. Hold on. Is it me, or do this sound like a lie? Is it me, or do this sound like a lie? At 9:33, Judge Glanville exited chambers, turned right back around, and came back in and with Mr. Woody Chamberlain. Really? So this conversation is not, and y'all know the way women talk. Let's keep it real. Women and men talk. This conversation wasn't 30 seconds, wasn't 40 seconds. The court reporter said, we're off the record. Brief recess. And all of this within 59 seconds, Judge Glanville walked back in after leaving out. Who do y'all think y'all fooling? Ms. Love said Ms. Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. The judge said, where's Mr. Copeland? Hold on, wait a minute. This is why I said it don't make sense. Judge Glanville and Mr. Chamberlain, okay, enters chambers, okay, at 9:34, okay. The court, where's Mr. Copeland? Mr. Chamberlain said they took him upstairs to the tank in 9. The court, okay, can we bring him out to blank? Can we blank? Mr. Chamberlain, your chambers is being used. Blank, I mean, your courtroom is being used. The judge, let's bring him in here. Mr. Chamberlain, all right. So let me see if I can get that done. And then Judge Glanville doubles down and reiterates, let's bring him in here. Okay, thank you. We'll just bring him in here. So you know what you're doing is wrong, but you proceed to continue to do what you's wrong, Mr. Suge Knight Glanville. Suge Knight Glanville, Cash Money G, Cash Money Fanny G. Old Funky Hilton. Wide shoulder love. I mean, come on, man. The proceedings stood in recess from 9:34 to 10:03. Mr. Copeland entered the chambers at 10:03. Also present were Judge Glanville, Assistant District Attorney Simone Hilton, and Attorney Caleb Bumpus. Court reporter Christian Weaver, investigators Antonio Lang and Rashad Hamilton, and Deputy Houston, Deputy McPherson, Sergeant Brown, and Sergeant Hall with the Fulton County Sheriff's Department. The court, okay, Mr. Copeland, can you let him know I got a hearing problem? Ms. Bumpers, okay, he said, can blank, he is hard of hearing. Oh my God, man. Oh Lord. The court, that makes two of us. I've got a hearing aid that's coming on the 27th of January. Of June. So I'll try and talk loud. Is it okay if I blank? Copeland, yeah, I can read lips. The court, okay, good. Mr. Copeland, good morning. Mr. Copeland, good morning. The judge said, all right, I just wanted to bring you over and let you talk with Ms. Bumpus and see if there is anything that you need to ask of your counsel or Ms. Hilton or the state or the court before we bring you out this morning, because it is blank. We would like to hear your testimony. And that is kind of where we are at this point in time. So is there anything you want to ask, Mr. Copeland? Well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. Oh, at that point, this case got to stop. At that point, this case got to stop. Because now he's admitting his guilt. So it says, well, I want to speak with you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. The judge said, okay, well, the only thing you can give is truthful testimony. Whatever you know is whatever you know. That's it. Ms. Hilton. And what we'll say blank, and Mr. Copeland and we have talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if you are blank, if any of your concerns deal with being locked up for anything, you can't. Ooh, like there's nothing that can happen. The feds blank. Uh-oh. She's given an indication that the feds is the only ones that can do something to him, which means they are already in talks and planning for the feds to take over this case. Here come trouble. Here come trouble. Ms. Bumpers, well, that's not blank. Ms. Hilton, it is true. Ms. Bumpers, no, I said that's not his concern. Ms. Hilton, if his concern is safety, we need to know that. Like, that's not expressed. So we don't know what the concern is so that we can try to resolve the concern. Hold on. I got a problem. Hey, Callie, I got a problem now. And the problem that I have now is that they don't care about his safety. They don't care about his family's well-being or safety. They don't care about nothing except for a conviction. That's all they care about. And that's all that I'm looking at. I'm looking at what's really going on, and I'm looking at what's not being said. They think people stupid. They already done put out there that they are pretty much in talks with the feds. So they probably feel like they losing this case. So if they lose this case, the feds going to pick this up somewhere down the line. So the best thing that Woody and everybody in this case can do is what Jeffrey should do, is when this case is over and they win, if they win this, move the heck away from Georgia ASAP. Because they will always have a bullseye on their back. So she said, this is what I'm saying. Mr. Copeland and I have had conversations before. I understand some of his concerns is potential criminal liability. Hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. Oh, whoa, wait. I need somebody to help me with this. So federal statute of limitations on murder is 5 years. Can somebody find that and put it in the chat for me? So the federal statute of limitations is 5 years on murder. I didn't know it was a statute of limitation on that. Because if that's the case, I'm going to go back to R. Kelly case. If murder is supposed to be the highest crime in the land, and this statute of limitations is up after 5 years, allegedly consensual sex. Well, I ain't gonna say allegedly. No, consensual sex, allegedly forcible sex, so they say. Their statute of limitations are longer than murder? Hold on. Am I seeing the justice system being twisted now in jurisdictions? So then it says, so there's nothing blank like I researched it this weekend again. Both those statute of limitations for what you and I talked about, which is in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that is the concern, there is none, because you cannot be prosecuted. So pretty much they want him to put Thug and him away. Then it says the federal statute of limitations is 5 years. Hold on. The federal statute of limitations is 5 years. So anything in 2015, 5 years would have been 2020. Anything statewide is 4 years. It would have been 2019 finish. So you mean to tell me that R. Kelly has been prosecuted for stuff that was beyond statute of limitations, and they chose to try to hijack it and make it more, which leads you to believe that the feds had a greater interest in the R. Kelly case. Next concern, what may happen in the street? You know what we talked about, what we can do as far as living and all of that. Once again, it's coercion. What we can do as far as living and all of that, yeah. And we know from us looking at Rashonda Landfair, y'all can move Woody and his family out of state, put them in a nice upscale townhome or home, and give him unlimited food stamp capability. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I've got to tell you that. I've got to tell that to you. What I've got to say to you, we do not want you sitting in the cab or whenever they got you because of this. I know you want to talk to me on, I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpkins, I'm here. But we do not want you in custody. You will not blank this order. Ooh. I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it. Literally, blank judge. You might want to close your you might want to close your ears. Blank, if you confess to a murder on the stand, if we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. Oh my God. Now it shapes up more and more for me. This case is showing precedence of what happened in the R. Kelly case. So how many unsolicited co-conspirators went down there on R. Kelly and got the same immunity if everybody that testified got this same immunity? Make it make sense. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations with Mr. Long, as I'm saying in front of Ms. Bumpus, as I told you, that is what this order says. Ooh. Yeah, Callie, it's hot over here too. The court. And that is direct or cross-examination, Ms. Hilton. And that is direct or cross-examination. Why is both of them saying it together? So if you are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Mr. Copeland, I got family members watching this trial. Hold on, but I gotta get my Woody at. Hold on. I got family members watching this trial. And I don't want my nephew and them to hear the things that I may be involved in and think is okay, Ms. Hilton. But I think that's a separate conversation you can have with them as an honest individual. Like, look, nephews, I done lived the life that I don't want you to live. Don't go through what I've been through. But that's not blank. That's something you can have outside of being in jail, because that's a better conversation you can have with your nephews in person. But they shouldn't have to come to the DeKalb County jail because you are being held in contempt. Stop for a minute. Why is he being held in DeKalb County when the court trial is happening in Fulton County and he lives in Fulton County? Can somebody explain this to me? Suge Knight Glanville, Funk Box Hilton, Wide Shoulder Love, Cash Money Fanny G. I need somebody to explain this to me. Why is he going to DeKalb County when he live in Fulton County and the case is in Fulton County? And normally the jails don't transfer cases like that. So it says you can have that conversation with your nephews tomorrow in person. You can have that conversation with them. You can have that conversation with anybody. You know what's coming up this weekend. Why are we in jail? What are we doing, Mr. Copeland? But y'all did this intentionally. Uh-oh. Yes, Woody is funny as I don't know what. But y'all did this intentionally. Ms. Hilton, no, we did not. You and I had this conversation, Mr. Copeland, on Friday morning. Mr. Copeland, you knew my child's birthday was next week. Ms. Hilton, but what did I tell you? when we met with each other, I said to you, blank, you asked me, what is the one thing that's going to get me in jail? Didn't you ask me that? And what was my response? If you plead the fifth, and that is exactly what you did on the stand, Mr. Copeland. But what did I tell you before I got to that point? I told you the whole time Tuesday, Wednesday, Thursday, blank. Yo, I love Woody, yo. That nigga funny as hell. He said, but what did I tell you before I got to that point? I told you the whole time, Tuesday, Wednesday, Thursday, blank. It don't make sense. There's a lot of stuff that's taken out. That's why I'm reading it like this. Mama Murray says, setup. Of course. Ms. Hilton, but I told you we were giving you immunity, Mr. Copeland. If I know him right, he probably said, fuck that. I was pleading the fifth. If I know him right. Ms. Hilton said, no, you did not. Woody said, I told you every day I was pleading the fifth. Ms. Hilton, no, you did not. And we told you blank. Mr. Copeland, I told you my concern. Ms. Hilton said, and we said we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. And then I said, whatever your concerns are, we can give you immunity. I don't think Ms. Hilton understands the code of the street. Because from what I'm reading, she trying to get this boy killed. And that's not cool. So Mr. Copeland said, so I didn't tell you I lied on them to get myself out of the situation. Ms. Hilton said, you said you were a liar. That's what you said. You said you were a liar. Ms. Bumper said, was this recorded? Ms. Hilton said, no. And Ms. Bumper said, and did he ever say that Melnick was his attorney? Ms. Hilton said, no. This week blank. When we first met you in the car on Friday, we asked you, is Mr. Melnick your attorney? You said, he's not my attorney. I haven't even talked to him. Mr. Copeland, no, I never said he's not my attorney. I said I haven't talked to him. Uh-oh. They got the right one. They got the right one. Because he ain't going to play with him. Hold on. People texting me. What's taking me so long? Hold on. Somebody just told me something. So it says, you said he's not your attorney. You haven't talked to him. Then we continue to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Mr. Copeland, you didn't make me feel like I needed him. Ms. Hilton, but if you needed him, we would have said blank. If you would have needed Mr. Melnick, we would have said to you, okay, just call him. So, I mean, that is our position. We don't want you in jail. We just want you to be able to purge yourself by testifying. Whatever your truth is what your truth is. But you've just got to answer the questions. We believe that you're blank Whatever your truth is what your truth is. We know what you said before. I don't know what you're going to say on the stand, but what we know is pleading the fifth is going to keep you in custody. That's what I know. Now, how you answer your questions is how you answer your questions. I know what you said before. Excuse me. And I know what you said later. Blank. I mean, I know what you said before, and I don't know what you are going to say on the stand because you and I never went into full details about any of it. But what I don't, wait a minute. If y'all never went into full details about it, how is it that your partner can testify to everything of what he's supposed to be testifying to? Something ain't right. Something ain't right. But what I don't want, wait a minute. But what I don't want is you to be sitting here in custody. Mr. Copeland, you did it. Ms. Hilton, I did not do it. You did it by pleading the fifth, Mr. Copeland. You told me blank before you went to the judge with whatever the thing called you went to him with. You told me that I can't blank. When I'm asked a question, I can say I don't recall or I don't know. You told me that if I plead the fifth, blank, I mean something, blank, why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, blank, it was something. And then Friday, blank, Thursday or Friday came. And then y'all go tell me, oh, we went to the judge with this so you got to testify. If you don't testify, the judge going to lock you up. Ms. Hilton, right? Oh my God. She just acknowledged of setting him up. Oh my God, bro. What the hell? Funkbox Hilton. Do you know what the hell you do? Where they find these DAs at? Listen, I need to go. Listen, I need to go be a DA. Honestly. Because I can do way better than this. I can do way better than this. Oh my God, like this is crazy. I can do way better than this. Mr. Copeland, but I told y'all that. Ms. Hilton, no, you did not. Mr. Copeland, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Tell him, Woody. Tell him, Woody. Yeah. Tell him you from zone 6, boy. Tell him, Woody. Ms. Hilton. And I said, I don't know what happened. Only you know and them know. I said, but you never said I am pleading the fifth. You said, what if I do this? What if I do this? What if I do this? Mr. Copeland, I told you, I said, I'm going to plead the blank. You said, why would you plead the fifth to something that you know you didn't do? Ms. Bumpkins, so if you didn't have immunity prior to, is that what you are saying? That you feel like blank, he didn't have immunity prior to? Mr. Copeland, immunity came Friday, right when I went to jail. Ain't that what I told y'all? Ain't that what I told y'all? And other folks were trying to say, oh no, he lying. He don't know what he talking about. What he just sat there and told you. It came when he went to jail. Ms. Hilton, the immunity only came after Mr. Melnick blank. That was Friday when he went to jail. Ms. Bumpers, hold on. Ms. Hilton, the immunity came after Mr. Melnick sent us an email saying my client is pleading the fifth. That was on Thursday evening at 6 p.m. Ms. Bumpers, okay. Ms. Hilton, so after that, that was an empathetic, he is pleading the fifth. Ms. Bumpers, Ms. Hilton, we came and we got this sign. Uh-huh. And then Friday morning came. Okay. So between Friday evening, Mr. Melding reached out to us, said he represents him. He's pleading the fifth. Ms. Bumpers, okay. And when was the last time you talked to him before Melding got involved? Ms. Hilton, we talked to him earlier that day on Thursday. Okay. And then how did blank speaks inaudibly to Mr. Copeland? Mr. Copeland, he called me. He called me. Ms. Bumpers, okay. I was just trying to get a timeline. Sure, right. So we have been talking since last Friday. So I met with Mr. Copeland last Friday, I think, out in the neighborhood. Then he came on Tuesday for court. We talked briefly on Tuesday, and then on Wednesday he came. Copeland, Thursday. Miss no, blank. I think he only came 2 days. So it had to be Wednesday and Thursday he came. It wasn't Tuesday. It was Wednesday and Thursday he came. So she's being caught in her lies too. And then on Thursday, once we left, is when Mr. Melding reached out to us and said, my client is pleading the fifth. And at that point is when we went the next morning and got the immunity motion. Wow. This is exposing a lot. And then we spoke on Friday morning. I handed Mr. Copeland this agreement and let him know that he has immunity and that anything he says we can't use. And then Mr. Melding came and then we had court. Ms. Bumpers, so you are pretty much saying you didn't ask for this. Ms. Copeland, I didn't. Ms. Hilton, but we gave it. He doesn't have to ask for it. Ms. Bumpers, I know. I mean, he's just saying. Ms. Hilton, right. He doesn't have to ask for it. But to alleviate whatever his concerns are, we gave him immunity. He didn't have to ask for it. I'm lost. Wow. Ms. Bumpers. So if he wouldn't have had this, I'm just saying this so he can understand it. I'm walking him through. Ms. Hilton, would he still have had to testify or would he have been able to plead the fifth? That's what he's saying. If he did not have immunity, yes, he could plead the fifth. That's what I'm blank. That's what he's trying to say. He's trying to say he didn't ask for this. Ms. Hilton, but he doesn't have to ask for it. Now that we have given it to him because that's on us. So now that we have given it to him, it's an order. He can still choose blank if he's blank. If this is the road he wants to take, then he'll just stay in custody until the trial is over. And when we say the trial is over, every last defendant has been tried, not just these 6, the other ones too. Mr. Copeland, I done did longer time. Ms. Hilton, all right. Mr. Copeland, I'm telling you that you are literally immune from prosecution from anything else you may say. That's that. Oh my God. So the choice is always up to you. But we wanted to put on the record, the state does not want you in custody. What the state would like you to do is purge yourself from blame. Mr. Copeland, what purge yourself mean, Ms. Hilton? Meaning that you are no longer in custody. And the way that you purge yourself is to testify. That is kind of how it happens. And that is what the state wants you to do. We don't want you in custody. I can't say that any other different way, but we don't want you in custody. The only thing that's holding you is you refusing to testify. The judge. So do you have any questions? Any other questions? Basically, if you invoke the fifth blank, Mr. Copeland, I don't trust blank. I don't trust blank. I don't know what's going on. I don't trust nobody. I trust her word, but I don't know what's going on, Your Honor. Ms. Hilton, this is your insurance. I don't know if you want to break that down to him. Ms. Bumpers, well, he doesn't want that. The court, but he's been given it. Oh my God. Oh my God. This is the judge, but he's been given it. See, that's the challenge. Mr. Copeland, is that if they didn't give you the immunity, you could invoke your Fifth Amendment privilege. But what the state decided is that, as they said, your testimony is worth more to them at this point in time, and they really want to know what you have to say. So they have made a blank from the state's perspective. They are really forcing him to do this. They have made a decision to give you immunity, so you no longer can invoke your Fifth Amendment privilege. You have to testify. What? So that's the difference in this particular scenario, is that they have taken away blank. Well, you can still invoke your Fifth Amendment privilege. You still can do that. But the consequence of invoking it is you will just remain in custody. So if you testify, you get out of custody and you stay out of custody until you are done. Yo, this is crazy. This is really crazy. Mr. Copeland. And then if I don't testify, I have to stay in until when? The judge, until the trial is over, until all the defendants have been blanked. I've got these 6 that we have right now, and then there's another 6. Miss Hilton, no, there's another 12. What? The court, there's another 12 or thereabouts that are still outstanding in various forms or another. Mr. Copeland, can I speak with her for a second? The judge, yeah, sure. Judge Glanville, Assistant District Attorney Simone Hilton, Court Reporter Christian Weaver, and investigators Antonio Long and Rashad Hamilton left chambers at 10:17 a.m. and returned at 10:33 a.m. Mr. Copeland, my question is blank. I can ask you a question. The judge said yes. Mr. Copeland, so my question is blank. So what I was just asking her was, if you ask me a question and you feel as in I was lying about it, you will lock me back up. Ms. Hilton, no. If you blank, so you are saying, you say I didn't talk to Dame Keon. Blank. Well, no, I can't talk about that because the judge is in here. You are asking, for example, if you said before that the sky was blue, and I asked you on the stand, what color is the sky? And you say, I said it was red. I'm going to say, no. Back before you said it was blue. Is that what you are trying to ask me? Ms. Bumpers, So explain the independent evidence. If he says he did something and you know he's not telling the truth, what happens? Ms. Hilton said, if he said he did something and he did not do that thing, Ms. Bumpers, if you believe he did not, so if you believe that he's lying about that, Ms. Hilton said, then no. If he admits to doing something on the stand, Ms. Bumpers, Ms. Hilton, blank, and he did not do that thing, blank. Ms. Bumpers, Ms. Hilton, blank. I'm going to say, is that the first time you are saying that, Ms. Bumpers? And you have independent evidence to prove it wasn't him, then what? Ms. Hilton said, then nothing. What do you mean, like? So then he will be fine. Yes, but blank. So you are okay with him if he got on the stand and said things that weren't true? Ms. Hilton, no. I want him to tell the truth. What have I always said to you? I want you to tell the truth. I don't know what's going to come out your mouth. I expect you to tell the truth. If you say something that is inconsistent with what you said before, then I'm going to ask about the inconsistencies. But I expect you to tell the truth. What you go on the stand and do, I don't know. I don't know what you are going to do. I want you to tell the truth, but I will deal with you, not blank. You saying something different in the manner that I normally do, Mr. Copeland. If I'm saying something different, right? Blank. So when the police question me, they done question me every time they lock me up. I don't know how many times that was. I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Ms. Hilton, okay, so you can say I don't recall. That is how that works. I don't recall. Ms. Bumpers, and he can say that to every single question. Ms. Hilton, I will hope that that is not the truth, because I think there are some things you do recall and some things you don't. But the things you don't recall, you don't recall. And then I will go through my process of what I do. You can talk to him about what impeachment is. That won't get you locked up. Impeachment will not get you locked up. You can talk to him about what impeachment is. If he says, I don't recall, blank, Mr. Copeland, what will get me locked up? And Ms. Hilton said, what did I tell you? Mr. Copeland said, I don't know. Well, she did say that. And she did say, I don't know. So Prima in the building. I ain't know my sister snuck in here. Why wouldn't they impeach Woody? Ask yourself that. That's a good question, Prima. You know what? Call in, Prima. Hold on. We're going to do it like this. Call in, Prima. Because we're going to ask some questions. We're going to ask some questions up here. I'm going to put the call in number up there. Four. What is my phone number? 44. What is my phone number? All right, hold on. Hold on, Prima. Hold on. Because I want people to hear you. Hold on. Let me get this Bluetooth going. All right. Say something, Prima. Prima. Hold on. Prima. Hold on. I'm going to get this right. All right. Say something now. I don't know. Hold on. Yeah, well, hold on. That's on my end. Hold on. Hold on. I don't know what they doing. Hold on. That's on my end. Hold on, Prima. Hold on. Let me get this straight. Connect this back up. Tell us. All right, there you go. Hold on. Because now I can't hear. Hold on. Prima.
Yeah.
All right, now go ahead.
Yeah, I had to step outside. I don't want no real kids to trigger nobody.
Right, you know the real kids will trigger people.
Yeah, they just be doing goofy shit. Anywho, yeah. So ask yourself, why y'all think they don't want to just go on and impeach Woody, get him on out the way?
I don't know. Tell us.
Why wouldn't they impeach Asriel, Demetrius Smith, Lisa Van Allen? You know, do I need to keep going on?
Well, because they need some more lies to come out. But then, but Woody already told him that matter of fact, he lied about everything.
Yeah, but look at how they trying to frame this shit. He part of the so-called enterprise. That's YSL.
I didn't think about that.
So if I'm trying to connect this person, even though I know he ain't reliable as shit, but I want to attach his crimes over here, why not let him just keep talking? I'm going to let the jury pick and decide what they going to do.
I didn't think about that.
That's all I'm saying. You putting on record bullshit.
I didn't think about that. And Woody is finessing them the whole time to make them talk.
Yep. And then did you not see Woody on Kayla Bumpus live not too long ago?
Yeah, I seen a couple of them.
What type of stuff is it?
Like,
and then they keep talking about the state is watching. We know the state is watching. The feds watching. Everybody watching. We know this. And y'all giving them a show. And I'm just trying to look at, like, make this make sense. It's not adding up.
You are really opening some things for me because I didn't think about that.
I'm telling you, when I watched this R. Kelly stuff fall out, I knew we was.
This ain't no regular Rico stuff.
So you said it's not no regular Rico stuff? God damn it. What is wrong with this phone? What you said? It's not no regular Rico stuff?
No, you see these people trying to finesse. You see these people trying to build their allegations against Young Thug and his group. And mind you, way in the beginning, you remember they talking about all these people taking pleas and taking pleas and taking pleas, and then come to find out they start backing out of it.
Mm-hmm.
Yeah, why do you think they did that? Again, they just be trying to pressure people to talk and give them information and corroborate they bull crap.
I didn't think about that.
It's real.
You giving me something to think about for real.
Go and look at some real Rico cases, and then go over here in Larry Hoover case and look at the fact that even though he has disavowed this gang, told these people he ain't got nothing to do with none of these hybrid gangs and stuff going on around here now, all these get back gangs and all that.
Mm.
He telling these people I ain't got nothing to do with that, but they gonna keep him locked down. Why? As a symbol to us. We want to let our kids just sit here and do that gang stuff and then be surprised.
Rico.
This is crazy. This is crazy for real.
Yeah, I just thought I put that out. Just think about it. Why wouldn't they just impeach him?
This is next level. Like they said in the chat, this is extremely trickery. This is next level.
They playing. I think this is one big social experiment. They is playing in our face.
But I know when the trial and resume, I'm gonna be at the courthouse every day. So I'm gonna be calling shit out.
See, that's what they need, and that's what I don't like about these so-called bloggers on here. They not here to trial blog and none of that. They just here to be in the mess and try to be relevant.
Nah, cause I'm gonna call stuff out. And I'm gonna go live in front of the courthouse and call it out in front of people. I don't care.
It don't add up.
Right. Because this don't make sense. And then on top of that, if the jury and everything is sequestered, wouldn't your witnesses be sequestered?
Yeah, they didn't say they can't talk about the case on platforms and whatnot, but they still on here indirectly talking about the case and things that went down. Like, make that make sense. You ain't have no problem giving all these survivors over here a platform to tell their testimony.
Right. So why can't you give them a testimony? A platform.
Let's figure it out. They want to selectively do things trial by
error.
The community. Yeah, basically.
You giving me something to think about, man. Like, damn. I ain't thinking. But then you giving me something else to think about, too.
What's that?
You know I ain't gonna say it on here because somebody gonna try to steal it. You already know.
You know how they do it. Then they gonna come out like they just thought up the shit.
Right.
Oh, excuse my language.
So I tell you in private, but I got an idea. I really got an idea.
I think more content creators need to get together and combat all of these little agents of chaos on these platforms just playing games.
Well, you know what they're gonna say? They bullying us.
No, we're trolling. That's what we're doing. We're gonna troll you like you trolled us.
And then they're gonna go on their backup channels and say, it's the guys that's coming against us women, y'all.
Nah, it's the women. Like I said a long time ago, even with these little thoughts and stuff, they being encouraged by all these older people and their feelings about other stuff.
Mm-hmm.
That's what that is.
Yeah, I think I'm gonna do that, but I got an idea that's gonna include you. Yeah. Mm-hmm.
Yeah, just hit me up. I'm gonna go back in here and get back in your chat. I just wanted to put that out there.
Okay. Oh, where can they find your cakes?
You already know, primadonnapastries.com.
And where can they find you on Patreon?
Patreon.com/Primadonna News.
And where can they find your YouTube channel?
Primadonna News, same thing.
There you go. You got it from the great Prima Donna, y'all.
Y'all have a good one.
All right, you too, sis. Mama Mary said, that's falsifying information verbally. Facts. So, I'm lost. Like I say, I'm going to be the one to put this thing, to put the nail in the cast, in the coffin and all that craziness. But if you want to call in, 404-914-7986. Y'all go ahead and call in. Hold on. Because, see, this is crazy. This is crazy. That's the call-in number, 404-914-7986. I want to hear from you, but until then, I'm going to get back to reading. Because we almost done. This one. Let me see. Lily Rose commented. Hold on, let me see what Lily Rose said. See the comments here. Okay, cool. Are you live on the DanaJay show? How can I help you, caller?
Sorry, I don't understand.
Huh? Hold on, because I don't know what's going on. Hang up and call back. Hold on, y'all. Because this thing acting crazy. I'm telling you, it's about to get ugly. So it says you can talk to him about what impeachment is. That won't get you locked up. Okay. What will get me locked up? What did I tell you? I don't know. Miss Hilton, what you did on Friday, I plead the fifth if court instructs you blank. Hold on. Mr. Copeland. So the only thing that gets me locked up is pleading the fifth. Ms. Bumpkins, yes. Ms. Hilton, the court instructs you, you need to answer the question. You say again, I plead the fifth. Again, you blank. That's what's going to get you locked up. But if you answer the question, that will not get you locked up, Mr. Copeland. So if you don't want me in jail, why you just don't let me go after the trial over with? Ms. Hilton, you are in jail because you are not answering the questions. The judge, because you have been given immunity. Ms. Hilton, because you have been given immunity. You are only in jail because you got up here blank. Mr. Copeland, well, what about this? I answer the questions. Hold on, y'all. Are you live on the Dana J Show? I can help you.
Hey Dana, this is Teresa.
Hey, what's going on?
How you doing?
I'm good.
Hey chat. Hey my peoples in the chat. Hey the Dream Team. Listen, this case reminds me of Medea Goes to Jail when Linda was pending up trumped up charges and reopening closed cases. Fannie Willis needs to go. She has to go.
Say that again.
That's all I gotta say. She reminds me of Linda from Medea Goes to Jail. Remember, Linda was the DA, and she was reopening up closed cases.
And
the movie was filmed in Atlanta.
Of course, I know where it was filmed at.
By one and only Tyler Perry. This reminds me of that movie, Medea Goes to Jail. This is a funny case. This case is funny. It is. It's sad that Young Thug and his crew is incarcerated over BS. You know, it's sad. It's a sad situation. You know, Woody is funny. He is funny.
Yes, he is.
He's funny. He is hilarious. I unbelievable. I never in 57 years of my life witnessed something like this in my life. This is sad.
Okay.
It's crazy.
So you said Fannie Willis need to go, right?
Yes, she gotta go. She remind me of Linda. Anybody ever watched Medea Goes to Jail when Linda was a DA and she was reopening up closed cases, and then Lance Gross played in the movie. He was getting ready to get married, and that's when Rudy was in there, and he ended up marrying Rudy instead of Linda. Linda went back. Linda actually got locked up. So this was Fannie Willis needs to do. She needs to go to jail. Everything that she's had done under the sun, and all the legal aspects in a case like this, any cases. Just imagine how many of our Black men and women are incarcerated under her. It's sad. Just keep that in mind. All these innocent people are locked up for her, because of her. Unreal.
Mm-hmm.
Yep. All right, then I gotta go, but that's what I was calling you for.
All right.
You know.
All right, and one more time. And one more time, Fannie Willis what?
Needs to go to jail.
And she need to get out of office, right?
Yep. Out of office and needs to go to jail. We need to do a movie need to come up with Fannie Willis goes to jail.
Okay.
Just like Medea goes to jail, Fannie Willis goes to jail.
Okay.
Let's see how that plays out. Yes.
All right.
And Woody be in the movie. Let Woody be in the movie, because you know what you mean.
All right. So I'll talk to you later.
All right, Jaden.
All right. So, and I plead the fifth, blank, Ms. Hilton, no, blank, Mr. Copeland, blank to the questions that I feel incriminate me. Ms. Hilton, but then that's blank, Mr. Copeland. I won't plead the fifth to things that don't incriminate me. The judge said the state can still give you immunity. They can give you immunity to whoever they want. Okay? And they can make that choice. I don't even make that choice. So if they blank, like I said earlier, they want your testimony. They figure it's blank, that the jury needs to hear what you have to say, good, bad, or indifferent. And what Ms. Hilton is telling you is just tell the truth as you know it, and let her worry about blank. I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. So hold on. The judge is curving what the DAs need to do to him to get what they want. Then he says, what will get you in trouble is you not blank, is you just invoking your Fifth Amendment privileges because you have been given immunity. Or as Ms. Love said this morning, remember blank? Ms. Love said, if you lie, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. Blank, I mean, that particular false statement. Mr. Copeland, that's what they're going to do. Ms. Bumpers, that is what I was saying. You will be right back here. Ms. Hilton, but if you say something that you know you did not do, like you admit to something you know you did not do, whether you blank, Mr. Copeland, like murder, don't have like no statute of limitations, right? Ms. Hilton, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it, Mr. Copeland. But y'all don't like blank, Ms. Bumpers. You can charge him with false statements and he will be back in jail. That is what I'm trying to say, Ms. Hilton. But if I know that you are lying about that, I do not intend to do that. What? Oh my God, bro. This is bad. If I know right now he's lying, I know he's lying. I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you are trying to say you did now. And that can be part of this. I know you didn't do that. I know you didn't do it, Mr. Copeland. But it's up to the judge to do that. Ms. Hilton, no, it's up to the state to bring charges. The court, excuse me, which is the judge. I don't have anything to do with that. I'm going to ask this question again. Why is he even in there taking part in this? Ms. Hilton, he has nothing to do with bringing charges. That's up to the state of Georgia. Mr. Copeland, can I call blank? Can I talk to my family? And I will make my decision right after I hang up the phone. Ms. Bumpers, he's saying he hasn't been able to speak to anybody. Ms. Hilton, his sister just called us. She blank. Mr. Copeland, y'all done me wrong. Y'all just hold me in jail. Don't let me get no PIN number, no nothing. Yo, Woody Bay playing. Woody like, man, y'all gonna stop playing with me. Ms. Hilton, we have no knowledge. We did not know you that you blanked. Ms. Bumpers, he hasn't been able to do anything, speak to anyone. Mr. Copeland, the jail system down, but y'all still putting people in. Ms. Hilton, that part I don't know. I know we have been in communication with your sister. Your sister actually texted us, Ms. Landsquat, to make sure you were okay. We told her we physically had laid eyes on you. I'll leave that up to the sheriffs. I don't know. Brief pause. Mr. Copeland. So what you think what she's saying? Ms. Hilton. Hold on. Oh shoot, hold on, y'all. Sorry about that, y'all. I had some media call from Colorado. Y'all know I'll be out there soon. Mr. Copeland, so what's the thing saying? Okay, cool. Ms. Hilton, I can tell you right now, blank, Mr. Copeland, I'm talking about that locking me back up. Ms. Hilton, we would have to bring charges. There will be no incentive. Mr. Copeland, y'all will. Ms. Hilton, we've already had this discussion. Mr. Copeland, look what you did to me. You waited until Friday and did this. I done told you every day before Friday came that I was pleading the fifth. Ms. Hilton, no, you did not. As a matter of fact, I'll last blank. The judge, Mr. Copeland, let's see if we can get beyond this, okay? Beyond what your concern is. You could have invoked the Fifth Amendment privileges. The state could have turned around and said, stop. Had me blank, go ahead and file that motion and giving you immunity. It was going to blank. I mean, they make that decision. They decided to make it on Friday. So even if you would have been more comfortable testifying and invoking your Fifth Amendment privilege, they could decide you as a witness, they want your testimony more than they do you invoking your Fifth Amendment privilege. So they can give you immunity. That's not true. Whoa. Hey, darling. Whoa. So what they do, that part, Mama Mary, they forcing self-incrimination. Yo, this is crazy. They gave you immunity, so you've got to testify. That's not true. So you got to testify truthfully as to what your knowledge of the particular incident is. I mean, so they were going to blank. They could have done that anyway. Even if they put you on the stand, they could have said stop and gone ahead and given you immunity. They could have done that. Mr. Copeland, so can I get it in some type of writing that if I was to testify, that if she feels as in I lied about anything, that they won't lock me back up? The judge, let me have that, Ms. Bumpus. Ms. Bumpus, hands document to the court. Brief pause. The judge, Mr. Copeland, on page 2 of the order, pursuant to OCGA 245507. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland and any proceeding or prosecution for a crime or offense concerning which he testifies under this order. Well, I wouldn't be comfortable with shall. I need to say shall not. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the on the order. That is not what it say on the order. And the order say shall be used against and against said Kenneth Copeland, not shall not. Am I the only one to see this? Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says in the order. Okay, the only thing that will get you in trouble is this next little paragraph. Kenneth Copeland shall be subject to prosecution or to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court in this state, the United States, or any other state. So basically, if you commit perjury, false swearing, or contempt committed in testifying, that means if you just invoke your Fifth Amendment privilege, blank, or failing to testify, you say, I'm not going to testify. All right. So the only two real things you can kind of get in trouble for are perjury and false swearing, as long as you tell the truth. So now they went from one thing to three things. This is sad. This is sad. This is sad. And they letting this go down. Hey, darling. And they letting this go down. Now, as Ms. Hilton and Ms. Bumper said earlier, you may have told or been asked about situations over and over again. They may have changed. What the state is asking you to do is tell the version that really is the truth. If they want to impeach you, they can do that. Or if the other side wants to impeach you, they can do that. You won't get in trouble for that. So now we understand. I always say, if you look at one order, you pretty much seen them all. So now we understand why an angry, lied to, disparaged Azriel got on the stand and said what she said, because she can't get no trouble because they gave her immunity. My thing is this. How is the courts okay with giving immunity to people to lie on people to have them locked up? Mr. Copeland, you said I will. The judge, you will not. You will not. Impeachment is not perjury or false swearing, okay? Mr. Copeland. But she said I can purge myself, though. Ms. Hilton, no. We're saying two different things. Sorry. Wait a minute. We're saying two different things. Sorry. So you did say it. Now you're apologizing to her about it. Then you said perjury is if you get on the stand and you say just a bold-faced lie, just something that is just wrong. Say you say I did something, and all the other times you have said I have not done it. And really, while it's perjury, it's really just an inconsistent statement. Like if you get on the stand and say I did X, but in 2015 you said I never did X. That is what I'm going to impeach. I'm going to impeach you on everything you said in 2015, meaning I'm going to say, okay, today you said I did X, but in 2015, blank. Lieutenant Dean enters the chambers. Lieutenant Dean, we have a security issue. We need to stop for a minute. If we can stop for a second, please. What the heck? Judge Glanville and Lieutenant Dean exited chambers at 10:45 a.m. Judge Glanville returned to chambers at 10:47 a.m. Ms. Hilton, I don't know what was told to you on Friday. I have no reason to want you in prison. You have spent enough time in prison for YSL, period. So why would I want that for you? That doesn't make no sense. I said it to you before, and I will say it to you again in front of all these people. It makes no sense, Mr. Copeland. You just said I'm going to have to stay in jail until the last blank. Ms. Hilton, if you don't testify, get this part through your head. Whoa. If you don't testify, that is the only thing holding you right now, is the fact you keep saying, I'm not going to testify. Blank, well, you haven't said it today. Blank, I'm not testifying. I plead the fifth. If you get up there and you blank, I want you to tell the truth. Like I said before, if you don't recall certain things, you can say you don't recall. That's fine. I want you to tell the truth. I don't expect you to remember every single detail from 2015. I just don't. No one here does. But what I do expect for you to do is answer questions so we can get through this, so you can go home, be with your baby for her birthday. See, these dogs deliver their... What? Oh, no. See, these dogs deliver their babies. Go talk to your nephews. See, these dogs deliver their babies. Go talk to your nephews and do all these other things. Mr. Copeland, how you know about my dogs? Because you told me. Okay, what's wrong? I'm stressing at another level. Like, I mean, can he blank? I'm saying blank. I'm weak, man. I'm not playing. I'm dead serious, man. Like blank. Ms. Hilton, this is what our position is. We do not want him in custody. We want him to tell the truth. We want him to testify. That's what will get him out of jail. And you know, you have to make blank, Ms. Bumpkins. If he decides in 2 weeks he wants to testify, then what? Ms. Hilton, if he wants to stay in jail for 2 weeks, then that's blank. I don't know why you would want to stay in jail for 2 weeks. I have no idea. Ms. Bumpkins, he just feels like he's under a lot of pressure right now, this second. Mr. Copeland, even at the jail, they are just blank. You can't give me house arrest? Ms. Hilton, no. You can go home by taking the stand and testifying. That's what you blank. The judge, and come back tomorrow. Ms. Hilton, there's no blank. We keep on saying yet, but there's no crime. We keep on saying yet. I don't know who is telling you about a crime. There's no crime. You have done nothing wrong except for not blank, Mr. Copeland. So why am I in jail then? Ms. Hilton, because you aren't testifying. Whoa. What the hell? Mr. Copeland, but that ain't right. I mean, but that ain't nothing wrong. It's not a crime. Ms. Hilton, it's not a crime, but you're in a civil contempt. What? A civil contempt is not criminal. Oh my God. Hold on. Hold on. Hold on. Hold on, y'all.
The wireless.
Okay. Hold on.
Welcome to Verizon Wireless. The number.
Okay. Cool. Yeah, civil contempt is not criminal. So I'm trying to figure out, why is he locked up then? The court, two things, because you invoked your privilege after you have been given immunity. That is why you are in custody, because blank, you get out by testifying. So you testify, you get out. That's why I was going to bring you blank, why I brought you here early today to just inquire about that. You can remain and hold your position of invoking the fifth or not testifying, but you can go back to prison, blank. You can go back to jail because that's blank. Mr. Copeland, you can't sentence me. Ms. Bumpkins, there's no sentence. The court, there's no sentence. The contempt is compliance. They want your testimony. That is all they want, whatever that may be. Mr. Copeland, I don't know what it is, Your Honor. Ms. Hilton, so listen, you are in jail for failing to testify. Then the judge said, failing to testify. Ms. Hilton say, not for nothing else. There is no crime. You ain't done nothing. I don't know if people are telling you that we are going to charge you with nothing. We are not charging you. The state charges you. There is nothing we're charging you with. You are only in custody because you have decided not to testify. That is it. Once you decide to testify, remember, oh, what the golly. So hold on. So he's in jail for not wanting to testify. I'm not understanding it. Wow. The court, remember that word you were talking about, purge? Mr. Copeland, the court, the judge, okay, you can purge right now. Purge, get yourself out of jail just by testifying. Oh, Mr. Copeland, I can purge and get out of jail. The court, yes, just by testifying. Ms. Hilton, not perjury. The judge, purge meaning you can get out of jail. You can get out of jail, out of custody just by testifying. Mr. Copeland, and what about the other one? The other word, perjury.
Call from 225-999-4225.
Hello? Hold on, y'all. Wow. So, Mr. Copeland, and what about the other one, though? Perjury. That's different. That's a different word, okay? Mr. Copeland, that can get me back in jail. Ms. Hilton, yes. Perjury is blank. Ms. Hilton, it's not blank. What you are saying is not perjury. What you are saying is what we call a prior inconsistent statement. Your example that you gave me, what if I said I did something and you know, and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Brief pause. Ms. Bumpus, you've got to make a decision. So if he starts testifying today, he's going to go home today. Ms. Hilton, he should, so long as he remains. But if you get up there and be like blank, if you get to testifying and then we get into it and you start saying, I plead the fifth, we're going to be back here again. Ms. Bumpus, but if he says he don't recall to everything, he'll be okay. Ms. Hilton, I'm not advising that. But so long as he answers the questions, that's fine. So long as he blank. Mr. Copeland, I did these crimes. I'm telling you that. Ms. Hilton, okay. I don't know what you are talking about, but blank. Ms. Bumpus, I think blank. Are you saying you want to get up there on the stand and say something? Mr. Copeland, no response. Ms. Bumpus, did we find out if he could talk to his family? No. Brief pause. Ms. Hilton, I mean, if it's okay, we got the sister's number. Mr. Copeland, as my attorney, you got a blank. Ms. Hilton, let me blank. If y'all want to talk, let me go somewhere where I can't hear you. The judge is over there, so just speak low so he doesn't hear you. Judge, hold on. Judge Glanville handed a document to attorney Caleb Bumpus and exited chambers with assistant district attorney Simone Hilton, investigator Long, investigator Hill Hamilton, and court reporter Christina Weaver from 10:53 a.m. to 11:28 a.m. The court. Okay, all right. Mr. Copeland, have you had an opportunity to talk to Ms. Bumpus, your lawyer, and Ms. Hilton, the state's counsel? Have you got any other questions? Mr. Copeland, no, Your Honor. The court, which is the judge. Is it your desire to give a testimony today? Mr. Copeland, yes, sir. The court, okay, all right then. Do you all have some clothes for him? Ms. Hilton, I don't know. Let me go take a look. What size are you? Copeland, I can't hear you. Ms. Hilton, what size are you? Little? Oh my God. Yo, he said, what size are you? Little. Investigator Hamilton, we had a large jacket for him on Friday. Large. Ms. Hilton, you had a jacket for him? Investigator Hamilton, yes. Ms. Hilton, oh, but he can't wear large. The court, what is your waist size? 34? Mr. Copeland, 32. The judge, chest, what are you? A 34, 36 chest? Ms. Hilton, probably 36. Mr. Copeland, not in my chest. What you mean? The court, size. Ms. Hilton, what size are you? Small or medium? Mr. Copeland, small or medium? Yo, Woody crazy as hell. Hold on. They are going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Mr. Copeland, y'all don't want to show the people how y'all did me. The judge, look, blank. Ms. Hilton, if we can't find clothes, then you may have to until tomorrow. Mr. Copeland, I prefer to go in like this. Ms. Hilton, I understand what your preference is. Nah, don't hide it. Whoa. Can you make him put on clothes? Ms. Hilton, no. I want to go in there like this. Ms. Hilton, fine with me. The judge, all right. Okay. Mr. Copeland, you ain't going to try and lock me back up for this. Ms. Hilton, so long as you testify, we will get an order to get you released. You see how dirty they are? Ms. Bumpers, today, the court, whose copy is this? The judge of that. Ms. Hilton, you've got to make sure you come back now. I want to be real clear. Mr. Copeland, when have I ever ran? Ms. Hilton, you have not. That's the only thing. You have not. The judge, whose copy is this? Ms. Hilton, that was ours. Do you want a copy? You can take it though. Ms. Bumpers, okay. Ms. Hilton, do you still have yours or you threw it away? Ms. Bumpers, I'm going to give him both of these things so he can have some information. Ms. Hilton, okay. The court reporter, are we off the record now? The court, are we done? Ms. Bumpers, yes, I believe so. The court, okay, we're good. See everybody downstairs in about 10 minutes. I got a question. When did the court ever, when did they ever go back on record? They never said that they were back on record. So when did they ever go back on record? So that means that they can fraudulently do anything that they want to do. Prima said, this is America. Facts. Yo. I hereby certify that the foregoing transcript was taken down. What? Hold on, bro. What the certificate? I hereby certify that the foregoing transcript was taken down. As stated in the caption, and the colleagues' questions and answers were reduced to typewriting under my direction. That the foregoing pages represent a true and correct record of the evidence given. I further certify that in accordance with OCGA 911-28A, I am not a relative, employee, attorney, or counsel of any party, nor am I financially interested in the action. This is the first day of July 2024. Christina Weaver. She need to be fired. She need to be fired. And this is just a transcript to say what happened. Nah, I don't trust them. I don't trust them at all. So I was going to do both of them today, but there's no way I'll be able to do Brian Steele's today. That's 223 pages. There's no way I'll be able to do that today. So, look, I thank y'all for joining me for every bit of 8 hours today, including that little 2-hour break. So 6 hours. Tomorrow, we going back at it, Brian Steele. Then Monday, we're going to talk about Agenda 47 versus Project 2025. But like y'all said, this was dirty. If you want to call in, call in. I want to hear from y'all. Hold on. I want to hear from y'all and see what y'all think about today. Do y'all think Woody was doing the right thing by telling the truth and telling them that he, lied about everything? Or do you think that they trying to play bully ball with him and trying to pretty much force him to say whatever? I see what y'all say in the comments, but I want to hear from y'all. I want to hear from y'all. They need to be fired, prosecution side. So if y'all don't want to call in, then let me know. Because I'm about to get up off here. It's been a long day. All right. Well, I ain't gonna hold y'all. Y'all know how we do. You don't have to be great to get started, but you have to get started to be great. Be someone important. Be yourself. And till next time, DanaJay signing off. But guess what? Them seasons jumping, and it go like this. The spices are in. The spices are in. Oh my God. We got DanaJay Hattie Lemon Steak Spice. Oh yeah. We got the DanaJay Lafayette Low High Rise Tropical Bang. Come and get it. We got the DanaJay Lafayette White Dirt, y'all. We got the DanaJay's Jackson Family Seafood Blend number 2. Oh my God. Then we got DanaJay's Lemon Family Seafood Blend number 1. We also have the DanaJay's Lafayette Low Rise Mild Heat. If you know, if you want that heat. Then we got the real heat. If you want the DanaJay's Smut. That's the extreme heat that got the Joker on the side. Oh my God. Come and get it. Come and get it. The DanaJay spices are running wild. I'm telling you, come and get it. After you taste these spices, you ain't gonna want nobody else's. I holler at you later. Hit me.
I don't like to waste time on stupid conversation. There's no profit in that. So if I'm around people that are always complaining with no solutions, then I'm wasting real estate in my brain for what I need to project. And what I project in my brain is what I project in my reality. So that real estate only has to be for evolution, things that are going to help me get where I got to go. You understand? Help me evolve. So if my conversation with you makes me stagnate, we don't have too much conversation either. I don't have no time for no stupid ass conversation.
Swimming in you. Said I'm gonna take her. Dipping your pool. Just go for a little dive.
happier. Hey, yeah, yeah, yeah. Sometimes a misty rain that gently touches my soul. Feels just like fire shut up in me. Yeah, simply lose control. Oh, rain down, follow me. Let your love just fall